All right, well, it's a little after 10, so let's go ahead and get started with the meeting today. I'm going to start by introducing a few people that we have with us today. First, Judge Sylvia Holmes, who's the Justice of the Peace here in Travis County, who has kindly stepped up to the plate to assist in light of Judge Nick Chu's decision as a result of his appointment to a probate court, not to serve this time on this group because of all of the demands on his time. So Judge Sylvia Holmes, welcome and thank you very much for joining us today. We're also joined by Kimberly Pack Wilson here in person. I had the honor of serving with her on the State Bar Board of Directors, and she raised her hand to be a part of this project right when she learned that it was underway. And she's been a dedicated member of the Scope of Practice Subcommittee all along, and we have her here today in part because Jonathan Bates, who is on the Scope of Practice Subcommittee and also on the working group, may have to step out from time to time due to work commitments. So she has his proxy to vote as needed for him during the meeting today. Also with us, perhaps not in this moment, but at some point along the way will be Paige Hoyt. Paige joined the Scope of Practice Subcommittee when we needed additional expertise on consumer debt matters, and she has been a dedicated member of that subcommittee. It's an area of the law that's pretty unique and a lot of us don't have expertise in, and so she has kindly offered to join us today to walk through the recommendations of the consumer debt subgroup of the Scope of Practice Subcommittee. What we'll do now, I think, is go around the room and let everybody know who's taking minutes and who's recording attendance, who's present in the room. I'm Kenan Wooten, co-chair of the working group.
I'm Lisa Hobbs, I'm co-chair of the working group.
I'm Kimberly Pack Wilson, here for Jonathan Bates.
Karen Miller, member of the working group.
Richard Lavallo, member of the working group.
Harriet Myers here is chair of the commission.
And then I think it's a good idea for people who are with us online to go ahead and announce yourselves again for the minutes to ensure that there's an accurate reflection of attendees. And I'm sorry that I don't see all of you, and otherwise I would call you in order. I see you, Judge Livingston.
Good morning.
I see you, Craig Hopper.
Good morning.
If there are others, I can't see you on the screen, and it's good to announce yourself now. There you go.
I'm Lonnie Summers. I'm with the National Center for State Courts, and I'll call on Ellen because I can see her.
Thanks, Lottie. Ellen Lockwood. I'm with the Paralegal Division, specifically chair of the Professional Ethics Committee of the Paralegal Division of the State Bar.
And Lonnie, do you show any other attendees, or do you have any other attendees?
Judge Holmes was just promoted to panelist, which is what had to happen in order to unmute yourself and speak.
And then we have Paul Furt and Renee Jefferson who are declining the promotion to panelists but are attending.
Okay. Lonnie, did you hear that? Do you know everyone who's present for the minutes? Great.
I did, and I appreciate that. Thank you.
Good morning, thank you.
All right, Lisa.
Okay, our first order of business is to approve the minutes. And those are on page 2 of the PDF that Kenan sent out on Sunday night, and I think might have been recirculated today by Ms. Summers. Are there any comments or amendments to the minutes from our July 27th meeting? Hearing none, I'll move that the minutes be approved.
I second.
We've got a second here, and all those in favor say aye.
Aye.
Any opposed? Great, the minutes are approved.
Great. So that takes us to item 3A of the agenda, which is the Paraprofessional Scope of Practice Subcommittee. I'll start this discussion, but certainly don't want to be the only one participating in it. I'm hopeful that all the members of the subcommittee and all the people here today will participate in the discussion. We just had Katie Kilmore join us for the record. Okay, so in the materials, there is a memo starting on page 10 of the packet. And this is essentially a supplemental memo to the last scope of practice subcommittee memo that was circulated. So you really need to kind of read them together to get the full background, but I'll go over the highlights now just so that everyone has that context, including those people who may not have had time to delve through the materials. So first and foremost, on the first page of the memo, you'll see the list of the tasks of this particular subcommittee. The tasks include looking at potential limits on the type of work that could be done by qualified paraprofessionals in the areas of law in which such work could be done. Looking at potential rule revisions that would be needed to authorize and define procedures for the limited practice of law by the paraprofessionals. Looking at eligibility criteria for clients of the paraprofessionals, and finally considering potential compensation sources for the paraprofessionals. As noted in the memo, the bulk of the work done by the subcommittee to date has been on the first two tasks. That is looking at the types of work that would be done by these qualified paraprofessionals, and also laying out potential rule revisions, or at least starting with that work. As of now, we haven't actually put all of the different recommendations in standard rule format. That is something that we want to do after we have further input from this working group. There is a summary of our meetings to date, but the big picture is we've met 6 times as a subcommittee, and there are materials available for each and every one of those meetings, including agendas, minutes, recordings, and other items that were discussed and considered. All of those are available upon request, so you can direct that request to me, to Lisa, to our other co-chair, Judge Massengill, or to Lonnie Summers from the National Center for State Courts. As explained in the prior subcommittee memo and at the last working group meeting, what we did as a subcommittee is divided and conquered, because there are several areas of law that we needed to consider for potential recommendations. Different people have different areas of expertise, different backgrounds. So we have 4 different subgroups of this subcommittee, and we have them laid out on the first page of the memo, again, page 10 of the PDF. It's the family law subgroup, the housing subgroup, the probate subgroup, and the consumer debt subgroup. And each subgroup, in between our subcommittee meetings, worked hard on developing recommendations for the subcommittee to consider, and ultimately for this work to consider. And I want to pause there and say what I should have said before, and that is that the members of this subcommittee have been working really hard, and I'm grateful to all of them. They've shown up, they've worked between meetings, they've exchanged ideas between meetings, and there's just a lot of thought that's gone into the recommendations that are before you today. That's not to say that they wouldn't benefit from additional thinking. That's why we brought them to you for discussion. But I did want you to know that a lot of hours have gone into developing the recommendations that are before the working group today. At the last working group meeting on July 27th, we had Jonathan Bates lead the discussion about the family law subgroup's recommendations. And we had Craig Hopper lead the discussion about the probate subgroup's recommendations. Nothing has changed in those recommendations since this working group considered them last time. So what you had as a working group appended to the memo for the July 27 meeting is exactly the same as what you have appended to the memo today from the from the family law subgroup and the probate subgroup. But we do have Kimberly Wilson with us, who can provide additional information on the family law subgroup recommendation to the extent we need to discuss that in greater detail. And of course, we have Craig Hopper with us again, in case we need to discuss in greater detail any of the probate subgroup's recommendations. What we have that's new today are recommendations from the consumer debt subgroup and the housing subgroup. And I'm not sure whether we have with us yet Professor Mary Spector.
She had texted us and said she had an administrative meeting and might arrive by 10:15, which
That's right.
is a few minutes.
10:15, okay. And do we have Paige Hoyt with us yet?
Yes, she's here as John Breaker.
She is here.
Yeah, I'm here. Hi, Kenan.
Hello, thank you for joining us. Paige, if you're ready to give an overview of the consumer debt subgroup recommendations. This would be a great time since the working group hasn't heard about those recommendations yet. If you just want to go over at a high level what they are to give people context, that would be very helpful. And for your reference, they are on page 18 of the PDF that Lonnie Summers sent to you via email.
Okay, I just got it from John, so I'm sorry.
We jumped ahead, but you're
Yeah,
okay.
yeah, no apology needed.
Yeah, okay.
I just dropped a link in the chat too, if that helps you.
I think I got one from John.
While she's I'll give a little bit of background to everyone. Essentially, as of now, the recommendations from the consumer debt subgroup are limited to tasks that would be handled in justice court without a lawyer's supervision. And by way of background, we do have in the justice court rules of the Texas Rules of Civil Procedure a provision 500.4C entitled Assistant Representation that permits a justice court judge, in other words, a justice of the peace, for good cause to allow an individual representing himself or herself to be assisted by a family member or other individual who's not being compensated. So that's the existing rule we have on the books for work by someone other than a lawyer in the justice court setting that would apply to consumer debt cases. And Paige, if you're ready, I'll turn it over to you to take it from there.
Okay. Good morning, everybody. So this is the recommendations that we put together in regards to consumer law. You'll notice that everything is kept down in the justice court, even though you can appeal a judgment or a ruling up to county court. Because of the complexities that can arise once you get into county court, we've kept the paraprofessionals ability to represent a litigant or a defendant in a debt collection down into the paraprofessionals. And we say a general denial. And Kenan, I don't know if the committee talked about it. Would this include the debt collector? Would they be able to use a paraprofessional?
Well, I think that's a good point for discussion among working group members. It's not.
Yeah, so let's put that on the back burner. So right now we're focusing in on a defendant. So and we did start out with a much larger outline, and we reduced it down to just this. So there's been a lot of discussion on what they can and can't do. So basically you've got to prepare a general denial answer in a collection case. A general denial takes care of everything. There are some affirmative defenses that you would, and that's number 8, that if this is a debt that the statute of limitations affects, if you've got a stolen identity, all of these things would have to be in the affirmative defenses. But if a paraprofessional is trained, she knows what to look for. She knows what questions are key. They know what to look for, what to kind of dig into when they prepare that affirmative defense. Basically, this is, and the way that I always counsel my clients or applicants for our assistance, and no offense to any justices, JP courts that we have, but this is basically like the assistant manager. So you can talk to the assistant manager about a complaint. If you don't like the decision, you can always talk to the manager, and that's the appeal, and it comes up. So there are really, as long as the defendant gets their appeal in properly, they can have a second shot at it up in the county court. So so there are a lot of things that we believe that a paraprofessional can do. and then, but they would remain limited in the justice court. So they can get it to the notice of appeal that goes up to your county or court for the trial de novo, gets assigned a new case. At that point, if they want to retain counsel, they can. So we cast a wide net for what they're able to do down in the justice court. I don't know, Kenan, do you want me to go point by point?
No, I think people can read those, and I think that what we should do is discuss whether there are questions about the scope of the items in there.
Yeah.
I think we should open the floor for any questions about any of the items, any of the 11 items listed in the recommendation.
Yes. So I will open it up.
I don't see it on the list, but would a paraprofessional be able to perfect the appeal to county court from the JP court?
Yes, and that's the notice of appeal. So
Okay.
when you get the judgment, there's a dollar amount, and then the judge sets the bond, okay? In my world, my appeal is perfected when I file a statement of inability to afford costs. Any client I have qualifies for that. And so in the rules, when that statement of inability is filed, that's your bond posting. So that perfects the appeal. We put in a notice of appeal, even though it's not necessary. We, as a practice, we put in a notice of appeal, and that way everybody knows that we're appealing. If the person does not qualify to file a statement of inability, they'll have to post the bond, and that's what perfects the appeal. So they've got 5 days starting the day after the judgment to get this done. The justice courts are really good, in my experience, to explaining to the parties how to appeal the case. So I don't think that they can, you know, help them get a bond, but they can tell them they have to post that bond to the clerk. And that would be to help them do the notice or prepare a statement of inability. I think depending on, you know, I would say that they would have to have a retainer, that their service would go up to filing that notice of appeal, and then or the statement of inability, and then I would assume that the defendant would have to come up with the money and post it there. But it doesn't go up until all of that stuff is in the court file.
Question from Kim Wilson.
Do you think it would be worthwhile then to add on the prepared notice of appeal page and or a statement of inability to pay?
Yes.
The triggering mechanism.
Yes.
I see Judge Holmes is nodding.
Yeah, I think let's make it as comprehensive as possible. I know there's always a danger in putting too much in, but that's pretty much, that's items that need to be, that's a good point. So
And that would be, if I'm not mistaken, the procedure that's under Texas Rule Civil Procedure 502.3. Is that right?
oh, pop quiz.
I know.
Kenan.
Nobody knows.
It's there.
Killing me, Smalls. All right.
Yes, the 145 corollary.
There we go.
There we go.
I have a question.
Yes.
Paige,
Commissioner Bowman.
with the.
Yes.
Is it, are they drafting it so that the defendant represents himself pro se? Because I think that if the notice of appeal has the professional, they sign it, you would assume that they're taking it into county court. And so I think we probably need to clarify It's a pro se.
Well, I don't do appeals from JP Court, but when I file my notice of appeal to the Court of Appeals from district or county court, I'm actually filing that in the district, the lower court.
Yeah.
And I don't know how that works at JP Court. And I'm
Well,
happy- Yeah.
once the appeal is perfected, the clerk takes the entire file and transcript and sends it up to county. And then county gets it and assigns a new case number to it. There have been times where I've assumed because I filed an appearance down in JP that they would say, okay, my representation continues in county, but I didn't get notices. So I've made it a practice now that I will also file an appearance under the brand new case number, so there's no question.
And that probably varies by the 254 counties, I'm guessing.
I'm sorry, I missed that.
That probably varies by the 200
Yes.
counties of whether they latch on to the representative in the JP Court or not. So we might need to work through that.
But, and I do think it's a good point to, that we specify, I don't think that the subgroup intended for the paraprofessional to be representing anyone in county court.
No, in fact, we made a decision to take out any type of language that would allow a paraprofessional to come into county. So it was discussed at length. But no, yeah, the paraprofessional stays down in the JP court. So
Draft something, depending on how this gets into a final word, like rule format that requires some language in the notice of appeal that I am filing this within my scope of practice. But I will be representing the defendant in her appeal to county court.
Yeah, that's a good idea, and just.
yeah, I like that.
Just for purposes of the record, and apologies if I'm stating things that everybody here knows, but the Texas Disciplinary Rules of Professional Conduct expressly allow a lawyer to limit the scope of representation. In our courts across the state, I know of only one, there may be more, but it's the Travis County District Court. So I guess not one court, but it's one body of courts that have a local rule addressing in detail limited scope representation. There may be more out there, but that's the one I know about. But the bottom line is, it is expressly allowed by our current ethics rules, which of course are applicable to the lawyers, but we have Lisa Hobbs here who will go over later, potential regulation.
And I've already written myself a note that says to add that to our professional code of ethics. So I'm on it.
Perfect. Great minds. Okay, and then going back to item 1, Paige, you had framed a question about the defendants it's meant to cover. Would you put that question on the table again for us?
Okay, hang on. Oh, there it is.
No.
Okay, so are we talking about the general denial in a collection case? Could you rephrase the question that you want me to pose?
Well, I think you had said, does it apply to the creditor?
Yes, does this apply to the creditor? So number 1, if it does apply to the creditor, would be prepare a petition.
Low income,
Yeah.
low income,
Yeah, I don't know how, but
there's the.
The comment being made in the room is in light of the client population, which is low-income Texans.
Mm-hmm.
It seems fitting to carve that out, but.
So to limit it to the defendants in a collection case and not not the debt collector.
well, I would limit it to low income Texans because I guess a creditor could technically be your low income cousin.
Yes, that's true.
This is true.
Great point. Okay, so
Judge Holmes has a question.
Judge
We
Holmes.
can't hear you for some reason. No, you're not muted. You don't appear to be muted, but we're not hearing you.
Can you hear me now?
Yes.
Okay, wonderful. I normally see low-income creditors as small claims, and in our default, the debt collection docket, it's almost always counsel. And I would prefer that you limit that to requiring that they have an attorney for the debt collectors. Simply because most of the time they have no idea. And they file incorrect documents with us a lot. And
For someone who doesn't practice in this area at all, are there particular words that you would recommend for the limitation?
Especially if it's, it's almost always an LLC. I see the same 4 or 5 credit companies being filed with us, and then, this lovely chain of title that comes through. Yeah, Sherman
Mhm.
Originators and LV&V, I know these well.
But
I'd
don't
say,
aren't corporations required to be represented by a lawyer? You can't be a corporation cannot appear pro se.
That's
So I
correct.
think that rule
least it's
covers
true
that
in-
problem.
I think so. And so I can't think of a time when I've seen on what is considered sort of that we sort ours into default dockets and small claims. And I don't generally get a small business owner who's made it into a default. They are filing for a breach of contract and a small claims up to 20,000, and they just get a judgment and move it along. And then maybe they bundle that up and sell it off to a collection company later. But generally I don't see it. So Judge Livingston, I think you're probably correct that it covers
Yeah.
itself.
I think that rule is covered, except in the context of evictions where there's a special rule for
Yes.
representative agents. Except for that, I believe, when I do my self-represented litigant presentation every year at the College for New Judges, I'm on pretty solid ground, I think, in saying that a corporation may not appear in court pro se. So
Yeah.
that should solve that problem. And if we use language related to low-income Texans, if they qualify, if it's a small, mom and pop person who's loaned somebody $500 and they want it back, and they're low income, I don't see why we wouldn't help them. But obviously the target audience are going to be low income anybody, but low income debtors are probably more likely to be the folks that end up coming for help.
And this wouldn't be pro se.
Right.
They would actually have
Right.
assistance, so this would
Assistance,
be
yeah.
better.
Yeah,
The actual rule, though, is the 500.4B, and a corporation may be represented by an employee, owner, officer, or partner of the entity who is not an attorney. I mean, it's already allowed in justice courts, not anywhere else. And in evictions, so,
So that's not limited to evictions, that's generally in justice courts.
yeah,
but
because there's,
just in justice court, not in any other court.
Yes.
right,
That's
So
fine.
yeah, I think limiting it to low income would be consistent with our charge. If they're low income, we want to expand access to justice to those that are low income. And then that way we're on, I think, solid ground.
Mhm.
And then that begs the question, what's the definition of low income?
Right.
Oh, yes.
Right, which is a question that is on the table for discussion, but not yet.
Yep. I can tell you how I operate. So, 200% and below the federal poverty level. So it's easy for me. But anyway, so we'll put that on for another day.
So while Kenneth's taking notes on changes we might need to make to the rules, are there any other comments on the list of 11 items in the consumer area of law?
This is Craig Hopper. I wanted to talk briefly about like 7 and 8, the discovery requests and affirmative defenses. And I don't practice in this area, so I'm not sure if this is a big problem, but I would think that preparing discovery and even responding to discovery is going to require much more training than many of the other things here on the list. And will we have somebody being able to respond to discovery requests so that if I'm a defendant and I have a paraprofessional sending something out and then the petitioner turns right back with their own discovery request to the client, now how are they going to respond with their own discovery responses since we don't have that as for the paraprofessional?
Down in JP, you have to motion for discovery. You're not allowed to just put in your standard discovery request 194s or whatever. So the judge develops the case, and when I first started practicing down in JP, I was using the regular rules of discovery. So I did, like my 15 interrogatories, these huge things. And then it was denied, or they said, well, you can't do that. So then I motioned the court. The court's like, are you nuts? They're like, you can ask 8 requests for production and that's it. So,
So there's oversight.
So
Yeah,
it's
the
kind of
only-
a lower educational bar then, do you think, for a paraprofessional?
yes, the thing that they would have to be trained in is the danger of the request for admissions. I think that's your most dangerous document. If they slip by that could be, obviously fatal to the case, but you appeal it up to county. It's, if things go south down in JP, you've got that chance to pop it up. But does that request for admissions travel up with that file? And probably the answer is yes. So there are some real dangers with that. And I think we discussed this, but if you're gonna, allow certain things for a paraprofessional to do, that's got to be one of them, because that's that could be part of the case. So these are genuine concerns, because if the court allows it, the request for admissions, they need to know those things have to be answered.
And with the discovery, if you file your motion to allow discovery, and I assume that's kind of a standardish form, that gets granted, then the defendant can prepare their discovery requests under this listing.
Mhm.
But do we also need that the paraprofessional can help them respond to discovery requests? Doesn't the other side get to do that?
Yes.
Okay, so we would say prepare and respond to discovery requests, I guess.
Yeah. And I guess the argument could be too, is there's nothing to stop the plaintiff under the current rules from, requesting discovery with a request for admission. So if you allow paraprofessional to assist them, they've got a better chance to make sure that, they answer those properly. So
Yeah.
I think it's moving in the right direction. There are so many pitfalls in debt collection. It can become we talked about this too. It can become very complex with just one document, or it can collapse onto itself and become very simple. It seems simple on its face, but it can get complex.
So kind of to summarize, this is better than nothing, and there's always the safeguard that if it all goes south, you can appeal it, and hopefully you don't have any deemed admissions or anything going on that really is going to sabotage the appeal.
Yes, sir.
Okay.
Yep.
I just want to note that Mary Spector has her hand raised.
Who does? Sorry, Judge.
Sorry, it's not showing up on the screen here. Professor Spector, we didn't mean to ignore you.
Is she in, Domingo?
Hello, thank you. I was an observer until now. Thank you.
Welcome to the party.
No problem. I will say that there has been some work by Texas Appleseed working to develop a form answer for use in debt collection cases. And it may be that some forms, it may be as part of a pilot project, could be used as, or encouraging use of forms in some way. I can get access to those to share with the larger committee and Paige. I meant to share them with you sooner, but as you were talking, I remember that I had not. So it's a pretty comprehensive form that it has been working with for some time. So that is a resource that's out there that could be available to persons to assist low income,
Yeah,
usually debtors.
I would love to see that. That would be great.
I'll be happy to share it with our subcommittee. or
Now, is that on their
subgroup.
on their website? Do you know?
I don't know, but I certainly
Okay.
can get it.
Okay, thank you. I appreciate it.
Mhm.
Yes.
Yeah, and since we're saying that this would cover representation by paralegal of a low-income creditor, we would probably need to change 5 and to say appear to prosecute or defend the collection agent. And then I'm not sure how you deal with, because I don't practice in JP court. But number 8, it would be prepare or respond to.
Yes, yes, yes. Yep. So anything, if we're to include the low income collector, creditor, we would have to adjust that language to put in both.
You could just say appear in a collection lawsuit, unless you wanted to very specifically make it obvious, but
For 8,
for 5.
I'm sorry, 5, yeah.
And 11 needs a little cue, maybe just negotiate a settlement.
Yeah,
There was some active discussion about that.
I know. Creditor, creditors. Well, it seems almost redundant. I mean, if we want to keep that language in there, you would have to put in debtor or a creditor or creditor's attorney, or take the language out.
Let's make it more general.
Negotiate the settlement.
Yeah.
Mhm.
I mean, that pretty much takes care of all parties, I think.
Would you say negotiate a settlement of a collection case though? Or what?
Yeah. Yeah, I like that. And then just take off the tail with the creditor's attorney.
It's interesting that you said that though, because there are other things that happen in justice court besides just collections. Like, I mean, they're sort of quasi contract occasionally. It's not just you owe me this, it's you came on my land and you cut down my tree and now you owe me $500. I'm not trying to be, but
Well, that's why justice courts exist, because we're trying to make it easy to solve problems. So the judge can decide what, if any, he's going to hear. So, but yeah, it is true. There's a lot of other things that could possibly come in.
so are we limiting this to collection cases?
I think so. I mean, that's my gut. That's my vote.
I don't think so.
I don't think so.
I would say if there's a simple contract
I'm with you.
dispute, it should be in there. I mean, why would you want to just have collection? I mean, if you want to open up why would you allow a non-lawyer to represent someone in a collection, but not in a contract dispute like the one you?
Mhm.
So I would make it broad to cover everything.
Mhm.
But I don't practice in serious, so I don't.
Yeah.
Yeah. Same.
Well, I have some because I live in a rural area and I was just thinking about, I don't do it anymore because I don't practice in justice court any longer, but I have, and I was just thinking about like even a construction, you didn't build my cabinets correctly and I had to pay for extra. So now I go to justice court to sue for that. That's not a collection. That's definitely more of a breach of a contract. But if we're going to allow people, and again, we've got the trial de novo, then maybe it shouldn't be limited to collections. What's your thought about that page though?
Yeah, what do you think, Paige?
I think it's mission creep.
Mm.
I think we're starting to expand, and there's other pitfalls with contracts. You know, you could it starts to get a little bit more complicated. Where sometimes you'll have the UCC involved. I believe, and please help me or correct me, I believe there are some mortgages that can be collected down in justice court if they're below the 20,000 and they're just, it's not a question of title. It can be collected. Now, are there pitfalls in the mortgage area? Did you, you know, foreclose on it properly? Things like that. So I think we start to get into more of a complex area, which I think is just why we're in the, I know consumer debt would include the contracts, and we did hyper focus on debt collection because that's where your volume is. If this is what the committee wants us to do, we're going to have to go back and review our recommendations because there are other areas that we have to consider where there could be pitfalls. And I see 3 hands.
Okay, we will start with Judge Holmes.
I think for me, I'm thinking in a practical sense about how I see these cases come in. And generally, I only see requests for discovery from defendants that have received legal aid representation, or they have hired an attorney, and it is a stock set of things. They want to apply the rules of evidence. And in general, I'm happy to grant them all of those things. And I rarely, if ever, receive a request back for admissions or discovery from the plaintiff's counsel because they have such a low burden to meet on a debt case. It's really four documents, right? That the defendant has showed up, all they were trying to do was delay and get them to sign a new payment agreement. So on the civil side of other types of cases, the explanation, you know, the example that someone came and cut your tree down, I see a lot of lawsuits between neighbors and small private businesses and back and forth. And until they come to court, I wouldn't generally know that they are being assisted by a non-attorney. If their cousin or their mom or their sibling or any friend of theirs is giving them advice about what to file with the court, they're not sending us a letter of representation, right? At best, we've received a general denial, and then maybe someone has advised them they can seek discovery. And if I receive something that seems out of the norm or expansive or beyond the scope of what would be allowed or what I think is reasonable to develop the case, we set a pretrial and then we get the parties in the room together. And of course, now we do that via Zoom, but I'm all for allowing extra people to assist because the rules encourage that already. And ultimately, what we're trained in Justice of the Peace Court and in training is to try to get all the information that's relevant and otherwise sort of, you know, reasonable and admissible. And you know, what is it? Less than 10% of JPs went to law school. So here in Travis County, we're an anomaly in that all 5 of us are licensed attorneys. If you talked about rules of evidence with many of my brethren, they're not going to have an idea what we're discussing.
Right. Thank you very much, Judge Holmes. Professor Steiker.
Yeah, the rule 500.4 allows corporations to be represented by not by an authorized agent, but it does not allow individuals. And the corporations and entities are generally not the low income. Occasionally they might be a lawn service or a cabinet maker or something of that nature. But and it's not something that we looked about we didn't look at it more expansively in our group, but if you want us to go back and talk about it, we can, but I would see that to be more fair to expand the authorized agent beyond the debt collection and the eviction cases to all cases, just like it is for entities.
All right, Professor Fortney.
Sure, and I apologize for my camera issues. I'm working on 2 computers. It's been many years since I've taught Texas procedures, so I had to look up the jurisdictional limit of what now it's 20,000 in justice court. And so from the standpoint of a non-lawyer representing someone in a contract dispute, isn't that going to require more of an understanding from the standpoint of affirmative defenses and other concerns? And so I think just from the standpoint of and what constitutes a contract, so unless there's a good deal of I think work on refining what that means, because there's so much that would be considered a contract dispute. So I would defer to the group that's actually worked on that, but that would just be some of my concerns, is that with that higher jurisdictional limit and what constitutes a contract, I think that there would be a good deal of work to be done from the standpoint of trying to determine whether there's some risks from the standpoint of the paralegal's knowledge base and the ability to effectively represent someone. So just a few thoughts.
Thank you.
So hearing all 3 comments, initially I was in the mindset with Susan, but then I heard Judge Holmes talk, and I know the purpose of this is to assist the process, and she's on the front line. And if her vote is this would assist us on the bench, then I'm going to shift my thinking over to expand to include the contracts, because that's our directives. What can we do to help the bench? But Susan's right, because there are some pitfalls, especially with that increased jurisdictional amount. Now we're starting to get more larger contracts in there perhaps, but I mean, we can go back and revisit it, because this is to assist the volume and the bench in dealing with it.
We have a question in the room, Katie Fillmore, a comment?
It's a comment. I serve as outside, general counsel, but from my firm to a construction company who sometimes gets sued in JP court by individuals. And some of these suits, when filed by an individual who's not a lawyer, are not really clear what they're saying. For instance, I had one that was alleging negligence for failing to comply with the contract, which was clearly a breach of contract claim, but it was worded as negligence. So however we decide to define what areas this paraprofessional can serve in, we need to be thoughtful that these petitions in JP court are not always clear. In fact, in my experience, more often than not, they are not clear what type of cause of action is being alleged.
That's a really good point. And one thing I just want to reiterate as we're talking about what to allow and what not to allow is this. The areas of law that we focused on as a subcommittee were informed by the areas of law that we perceived as representing the areas where there was a great justice chasm, the greatest need for more assistance, more access to justice. And so consumer debt was a category that came to us and that we focused on. There is, of course, need across the board. And we're not going to address it all, but there was a discussion by this working group, I think in its second meeting, that we would focus on particular areas, at least for now. And so the need is clear. The question is, do we go beyond the confines of the practice areas we've been focusing on thus far? Understanding there's no way to fill the chasm with what we're doing here. And I do think that's something we should decide today, because it makes a big difference in how these rules are drafted. So Lisa, you have something to say?
I do. I'm leaning towards, and this is just as a co-chair and not as necessarily a voting member, but just kind of push back a little bit on what you said, Kenan, is given the judicial oversight, as Judge Holmes has sort of articulated, I think, very well about like just sort of hand-holding in the process in general. And also just that these are de novo appeal to the county court. So to me, the risk seems really low. You know, and again, I always want to go back to what we're comparing this to. We're comparing it to self-representation in justice court versus some educated representation from the paralegals. And given the de novo review, I just think the risk is really low, that things could go so awry in the JP court that that couldn't be handled on an appeal to the county court.
Thank you. Yes.
I agree 100%. And I'd like to propose a much broader approach and say, why do we have to base it on type of case? Why don't we just say that in JP court, you can have paraprofessional representation and not delineate the tasks they can do? So across the board, whatever case comes in, a paraprofessional could represent someone. And so it would eliminate all the, saying they should do X, Y, or Z.
Well, and Paige is off of our screen now, but
I'm still here. My husband is going on a business trip, so he has to make lunch, so I had to turn the video off.
Well, I guess my question is, because I'm sympathetic to that position, except for in the consumer debt cases in JP court, there was a list of can-dos, and there might need to be, I guess, if we're gonna take that approach, a list of can't-dos, exceptions. You can be, a paralegal can generally represent in justice court, except.
You can't make a notice of appearance in the county court. So you draw the line. I mean, that's the only restriction I would take through that and say, can't do that.
But I'm just pitching it back to Paige to know why we have a list of can-dos. And what in making this list of what you could do, what was the subcommittee or the subcommittee worried about where we're, that there's risk to the public? If that's the right way.
Well, we started out initially saying, hey, 504 allows non-attorney representation in JP courts. And so I went to Justice Kelly, JP1 Parker, and talked to him about it. And his understanding is that I can let somebody come in to assist. If I'm thinking that it's not good, I can deny their assistance. And he was thinking that 504 covered it. So when we went back, we were like, well, okay, let's focus in on debt collection where the pitfalls are, and then we'll say this is what you can do, because the can't do's, I guess we're doing more of we'll focus on what they can do. I mean, we never even thought of what they cannot do. Because we may miss something. But is the gentleman that's recommending that we just have a broad, are you from the disability rights?
Yes.
Yeah, so you brought this up in our subcommittee before. And so our focus was on debt collection, so we kept it into debt collection. And that's where our hyper focus was. And then we just took the this is what you can do approach. It was just how we addressed the problem.
Professor Spector.
Yes, we did discuss that issue. That's because it's 500.4C about the assisted representation, Judge Holmes, that you brought up about, or Paige, I think you brought up the assisted representation question that a judge can deny it for good cause. And I think one of the proposals of the eviction group, although we didn't look beyond eviction, we did talk about providing a better definition of what assistance was to include representation or whether it was something else. If that helps, and if it does include representation in other matters not limited to eviction, then perhaps a rule change is appropriate to make clear that there is assisted representation in all cases. It may mean modifying, amending A and eliminating C. I don't know, but that's just a thought.
Richard.
I think we need to eliminate the word assistance and say representation, so we know what we're talking about. And then I'm worried about good cause. And
Yes, I am too.
find what is good cause. You could have a paraprofessional who goes into a JP court who's real aggressive and is a very good advocate. And the JP would decide, I don't want them in my court anymore. And so I think we really need to be clear about what is good cause other than a bias that a judge may have.
Yeah, it's interesting, some of those points you raise are squarely addressed in the memo from the housing subgroup, which of course we'll get to, but those are all excellent points. Yes, Jen.
And I wonder if under 500.4C, which talks about the assisted representation, I mean, we're almost sitting here saying that what that rule should say instead is the court shall allow, instead of may for good cause, the court shall allow an individual representing him or herself to be assisted in court by a family member or other individual who is not being compensated by that litigant. Because that's part of the discussion we had in housing, but I'm not.
Judge Holmes.
I'm gonna have to be signing off here in a few minutes. I'm president for my Rotary Club and I have to make the board meeting before our meeting today or on Tuesday. But I would absolutely echo those sentiments. I would change the rule to just say shall and get rid of good cause. Because as the judge, I'm absolutely given plenty of authority if this person is being combative or not assisting or means well, but doesn't really understand the law that's being, brought into court or that applies. I can, in a polite way, tell them that. We can stop that, say, don't need it. But to allow, to have the rule say that, give us any ability to say no to that person, I think would probably be utilized more often than we would really prefer. And good cause would be more strictly enforced than what this panel seems to be implying, and certainly what I would allow as myself in my court.
So one quick question, if you have just a minute before you go.
Absolutely.
500.4C, of course, in its current form is not about qualified paraprofessionals.
That's right.
And so it's instead about family member or other individual who's not compensated. So the question for you is, would you make those changes to the rule if the person providing the assistance is a qualified paraprofessional? Or would you make those changes to the rule regardless, such that any family member can come in, other individual, and the judge wouldn't have discretion to say, not today?
I would, and it's not going to affect me whether or not they're getting some type of compensation. I mean, are we going to really quiz them about, are you buying this person lunch when you leave here? If a paraprofessional wants to come in and assist this person, whether they're low income or not, I'm happy, because that's helping me to develop the case in a quicker, more thorough way without getting, mostly what I hear is just long emotional sagas that don't deal with whether there's a contract and we're meeting the basic elements and the burden of proof has been sufficiently met. So for me, when I look at 500.4C, I would rather it say the court shall allow an individual. End of story.
And that would be any individual, family member, individual who's not trained, or
someone who is. Again, if they've got just a friend who's helping them out, sometimes what I have is the person speaks, they have low English or reading skills and they need a grandchild or a neighbor to come in and help them understand the wording, the terminology, what's taking place. I'm going to always allow that, but I can definitely speak to to judges that I know in other counties who would, I don't think that's good cause, and say no. Because they don't maybe have the same interest in the case.
So then the question is, if you have an individual there in a representative capacity, as opposed to this word assistance, which we don't know exactly what that means. At what point does that become the practice of law that only licensed members of the bar can engage in?
The whole purpose of this is creating an exception to unauthorized practice of law, unless every paraprofessional works under the supervision of a lawyer. I mean, I know that if I had paraprofessionals in our agency representing people, I'd have a lawyer supervising. And I mean, hearing about, I don't do debt collection or whatever, but looking at those tasks, either people need to be specifically trained and certified that they're competent in that area, or I want some lawyer supervision. And that's where I tend to be more of a proponent of the Alaska model of having community justice workers that work in conjunction with legal aid or other nonprofits.
I'm less concerned about the unauthorized practice of law by a non-lawyer there, because at least in my experience, what I'm seeing from non-lawyers is sometimes pretty sophisticated though. And when it's not useful or helpful to the party, we just tell them, thank you, but you're not being helpful or useful. Please stop. And then we move on forward. And then always, you get de novo appeal. Both sides are protected by the beautiful de novo appeal. Even when you win, if you don't think you got enough an award, you can start it all over again. And then you get all the requirements where you got to have a lawyer be with you. So if we're concerned about access to justice, then allowing more people to come in and try to assist makes sense to me. Because again, I have lots of authority as the judge to say, please stop. That line of questioning isn't useful here. It's not speaking, it's not germane to a fact that I'm looking at.
Okay, thank you so much, Judge Holmes.
I will be rejoining this afternoon when I get back from my meeting. So thank y'all very much. And I look forward to all the notes from the committee. Y'all are doing great work.
My sense that I welcome challenges to is that we need to redraft a little here at the subcommittee level, because there's so many suggestions that have been made today, that it's not time to take a vote on the written recommendation that's been presented to this group. Do others have a different view?
I agree.
Agree.
Paige.
Yep, I do also.
Sorry, what, Professor Spector?
Yes, I agree also. I think we focused on practice areas. And I will say that being a part of the process has expanded my thinking on the subject also. And it's, she's left, but I appreciate Judge Holmes' perspective.
Yes.
And maybe, Kenan, because because that's our subgroup, or that subcommittee was definitely focused on the practice areas, but this is sort of evolved. We said the wrong word. I'm so sorry. This is evolved into a discussion about justice courts and representation there. So maybe what we need is because that's sort of a combination of our housing and consumer debt. Maybe those committees need to meet together to think about justice courts as a whole in general. And it would be interesting, because Katie, I appreciated your perspective as someone who represents, because construction companies, they seem to get a lot of that in justice court from just, it would be an interesting perspective from the entity that would not qualify as a low income tax, and like, how would you prefer that somebody have assistance as the lawyer who is having to be on the other side of that?
So to be clear, I don't actually handle many of these. I see them come in and then I assign them, but
She's like, I'm not interested.
What I have picked up from it is that a lot of times individuals do not know how to articulate what it is they're claiming. So we just need to be thoughtful about if we are going to limit the types of cases, are we going to have someone go through them to decide it's this type of case versus this? Because some of them are entirely unclear, but I mean, I would think, yes, any lawyer would prefer to be, litigating against someone who is trained as opposed to someone who is completely not, because it's just very hard to understand what they're even claiming.
Richard.
I hate to keep talking, but.
No, I'm glad you are talking.
But it reminds me of the stuff that we do. And we have, like, kids with disabilities, they have these IEP meetings where you have school professionals and you have parents and they work out a plan. Sometimes you have a family member who assists, that can translate or just be there for moral support. Other times, because of the way it's allowed, you can have a lay advocate representing you. And that's permitted. And so I would think in JP courts, given what we've heard, that because people because of language or culture or whatever, or just emotional, I mean, you're a parent, your kid's in JP court, you're gonna be with them, to allow for assistance. But that's separate from representation. And so I would divide it out and I would allow the assistance, but if someone is gonna represent, then they gotta be qualified.
Right.
And trained. And then they could do the representation piece, so they're.
Yeah.
And held to account.
Yeah.
And where would you draw that line between providing assistance and providing
I define it.
representation?
I would
How would
say,
you define it?
I would decide, emotional support, language, cultural, whatever, I mean, I don't know. But representation means more, where you're drafting pleadings and you're acting more like a lawyer, really, or a formal advocate.
Right, and going back to the point about the practice of law, because
I don't have a problem with that. I mean, the whole purpose of this is that we're carving out the practice of law. My view of this is that we're allowing non-lawyers to practice law, even though no one in this room wants to say it. That's the reality.
oh, no, that's the reality, but the question is, what do you have to do to allow that, right? And I think that's where licensure comes into play, because the existing statutory framework addresses.
So I'm less concerned about licensure because it costs. I would want training and wanting to make sure that the people that are doing representation are properly trained. And that at some point, a judge or someone could say, you're not properly trained, and say you can't represent.
Or supervise.
Or supervise, train, yeah, if you have a lawyer supervising you or whatever.
I think that you could, in this rule that's already in existence, bifurcate where you could say this assistance may for good cause shown, but shall if it is a qualified paraprofessional, or whatever language we're gonna use for the paraprofessional people, so that there is not that option by the JPs to say, no, you can't do this because there's not good cause. And I get that distinction. That distinction makes sense to me from a practical standpoint, but.
That makes sense, so it's kind of like treating the paraprofessional, in other words, the licensed paraprofessional, like a lawyer. The judge can't say, I'm sorry, lawyer.
You're outside.
Right, for that person who's qualified and meets the criteria that are set. Judge doesn't have discretion to send them away.
So we're considering creating a part D, a totally different category, or?
Or C1 and C2.
Okay, because Judge Chu said that the assisted representation, part C, is used quite a bit for, he has students who are part of like eviction proceeding or college age kids who are litigants and their parent will come. And he said that that happens quite frequently, so I would hate for what we do to prohibit that, which he thinks is working from moving forward.
So Katie, to that point, if you were to retain C in its current form, that language, but then add a separate provision that require the judge to allow the qualified paraprofessional to represent, would that address the concern you're raising? In other words, you don't mess with the existing language, you just add something else to address the qualified paraprofessional?
Correct.
Okay.
Yeah,
Yeah, I agree.
Yeah, and even, I mean, you just would have to sort of look at the rule because A says representation of an individual may represent himself, be represented by an authorized agent in an eviction case, be represented by an attorney, you could say be represented by a qualified licensed paraprofessional.
yeah. And it seems they've already started to kind of differentiate between assisted representation and actual representation there.
And I think this is a good segue because we've decided to take back to the subcommittee analysis of essentially rule modifications for justice court representation generally as opposed to particular practice area in justice court. So that's going back to the subcommittee for discussion, but before the working group today is a memo that starts on page 16 of the PDF that actually addresses some of the questions we've been grappling with. And Professor Spector, I want to follow your lead here. Do you want me to kind of lay the foundation like I did before and then let you go over the recommendations in the memo? You're muted.
I'm happy to do that, Kenan. I need to pull up the report. I'm at home and my screen isn't. Are you able to share the screen?
Well, we should be able to, but our fearless leader who could assist with that is not in her chair right now.
Oh, okay. I think I can do it from, I think I can pull it up.
If you send me a link, I can try.
I can share it too in the
Oh.
chat.
Lonnie.
Oh, in the chat, and then I'll pull it up. That would be great. Thank you.
Okay, great. Good idea. Thank you, Lonnie.
Okay, and while you're doing that, Professor Spector, I'll lay the foundation for the discussion. Okay, so starting on page 16 of the PDF are the approved recommendations from the housing subgroup of our scope of practice subcommittee. And you'll see that on the first page there, again, page 16 of the PDF, there's an overview of statutes and rules that address representation or assistance by people who are not lawyers. So first and foremost, there's an overview of what we have in the property code specifically for eviction cases. We have section 24.011A that's entitled non-lawyer representation and provides that in eviction suits in justice court for non-payment of rent or holding over beyond a rental term, the parties may represent themselves or be represented by their authorized agents who need not be attorneys. And if you scroll down a little under rules, you'll see that Texas Rules Civil Procedure 500.4A2 tracks that statutory language from the property code, and in eviction cases allows both the property owners and residents to be represented by an authorized agent. So here, unlike in the 500.4C provision, you don't have that good cause requirement. It's just simply tracking the statutory authorization from the property code. Going back to statute, section 24.011B of the property code addresses an appeal from an eviction suit for non-payment of rent in a county or district court. And the long story short here is that it allows for representation by authorized agent for an owner of property, but not for the resident. So that's a legislative distinction that's been made. And we don't see full language tracking that per se, right? But I would suspect that if the legislature had made a different call, we would see a broader provision in the textual civil procedure here. So the other provision in the rules of civil procedure that we've been talking about a lot today is actually quoted there on page 16 of the PDF. It's 500.4C, entitled Assistant Representation, and it allows the Justice Court for good cause to allow an individual representing him or herself to be assisted by a family member or other individual who is not being compensated. So that's the background in terms of what the current rules and statutes say. Again, we're focusing here on housing issues, but that 500.4C provision is of course not limited to eviction cases. It's justice court cases generally. And the final thing to point out is on the next page of the PDF, which is page 17, at the very top, you'll see a statutory notice that's required in citation from the court in an eviction suit. And so this is required to be placed on notice to the defendant on the first page of the citation in English and Spanish in an inconspicuous bold print. But interestingly, it does not address representation by people who are not lawyers. So even though the statutes allow that, even though the rules allow that, the statutory notice does not address it. So with that background, if Professor Spector is ready to go over the recommendations, the floor is hers.
Well, thank you. Can you hear me?
Shannon and Professor Spector, before you start, I just want to sort of make an announcement. Despite our efforts to try to provide lunch for you slightly later in the day, the lunch folks have decided to deliver early. So it is in the lobby. When you are ready to enjoy it, I would suggest that you consider enjoying it sometime between 11:30 and 11:40, because since it's already there, if you go too much past that, you might not enjoy it as much. So I just wanted to throw that out before you begin what I know is going to be a very robust conversation. So take it away, Professor Spector.
Well, since I'm not in the room, I will defer to those who are. And if you want to take your lunch now, we can come back, or I can set out the recommendations now.
It'll keep certainly till about 11:30, 11:40. I just wanted to throw that out so that you don't go much past that.
Okay.
You could go ahead and start now.
Okay.
Take a break at 11:30. So Professor Spector, I think it will give you enough time to lay the foundation and people can think about it as they get their food and come back and have the debate.
That would be fine with me. I would, when y'all are having your lunch, I'm gonna also exit for a time. So that would be fine if we set a start time afterwards. But in the meantime, I'll go ahead and present the recommendations of our working group. Can everyone hear me?
Yes.
Okay. We have identified 3 major recommendations. The first is simply to increase awareness of the various types of representation and assistance that is already allowed under the rules, which we've talked about at some length in connection with the debt collection discussion, and perhaps to encourage the State Bar or the Office of Court Administration to develop a toolkit to assist all litigants in justice court cases. And note that that's not limited to just eviction cases. The second recommendation is to talk about Rule 500.4C and clarify that this rule applies to non-eviction cases. So we reached agreement on that. So that is all cases in justice court. Although the first part, 500.4A, does permit an authorized agent to represent a tenant in an eviction case. So that is some limited representation already available. We also suggested providing standards for assessing good cause, for allowing a self-represented litigant to be assisted in court by someone who is not compensated and not compensated by the litigant. For example, good cause could be that the litigant needs language assistance Or as someone said, maybe it's other help in understanding the written materials or an inability to afford representation as well. The 2C recommendation, so I guess that's the fourth recommendation, is upon a showing of good cause to consider requiring a justice court to allow a self-represented litigant to be assisted. So it would not be a may, but a shall, and expanding the scope of the rule to allow assistance from individuals who are compensated by someone other than the litigant. So, and to clarify that there will be no cost to the litigant for the assistance provided. We discussed this at some length at our most recent meeting because technically a paralegal with legal aid or with a law firm who may be doing pro bono work is being compensated by either the legal aid agency or by the firm or by some other entity. And that assistance should not be so they are not charging the litigant for that assistance, but they are being compensated. So we wanted to make it clear that the rule applied to a paralegal or other individual who may be employed elsewhere, who is simply assisting the litigant. And then the fourth recommendation is to consider the use and potential definitions of the word assisted. So do we mean representation or do we mean something else? And to clarify, I think I heard in the room from some who would like assistance to mean representation. And that was one thing we wanted to bring to the committee to discuss. The last recommendation that was proposed, but that did not receive, how did you say it? There was not agreement on number 3. And that was to amend the Texas Rule of Procedure 510.4, which is the requirement for a citation in an eviction case to include a reference to Texas Law Help as a resource. It already refers to the Texas Bar. And also to include the authorized agent language in Rule of Procedure 500.4A2. So how did I do, Kenan? Was that it?
I think you did great. And some of these issues, of course, have already been discussed.
I was gonna say, didn't we vote in our subcommittee? I'm lost in the subcommittees, but didn't to approve the third one. Our recommendation was to.
Yes. So to be clear, from the scope of practice subcommittee, we met last Friday. All the recommendations that are on the page, but not in the footnote on 17, were approved. The suggestion in footnote 3 was from one of our subcommittee members, but at the last meeting didn't get support from the other subcommittee members. So that's where things stand right now. It's 11:26. We're gonna break at 11:30. Since we have 4 minutes, is there any item here on the recommendations that anyone wants to address before 11:30?
I have a general question that might be fodder for contemplation as we're breaking for lunch. For both the housing and the consumer subgroups. Y'all have focused on JP Court. And is there nothing that a licensed paraprofessional could do in county or district court who is properly trained and qualified in these 2 areas? And it's just a general question, because we are going to be allowing trained licensed paraprofessionals to do some things in the other subject matters in county and district court. it's narrow, but there's some things. And I just, because we don't have any real conversation, and what really prompted me is actually Property Code 24.011, which does allow the property owners to have a non-lawyer representative in their de novo appeal to county and district court. It seems to me that if the legislature says that a non-lawyer can represent property owners, that it's not too much of a stretch to say that at least a licensed paraprofessional should be able to do that same thing on the tenant side. So I don't know that we need to address that all right now, and I don't know how much it was discussed in the subcommittee meeting, but I did want to kind of posit that as just like a, sky view of where we're going and the disparity I see in the 4 recommendations.
I think the subgroup of the housing talked about the inequity of having the property owners represented in county or district court, but not the tenants. So I don't think that is a far stretch. And I don't know if we just got sort of caught with that's statutory.
Yep.
Which is not something we can change.
Well, I think this raises a point, and Professor Spector, I don't want to speak for you, but I think it's worth noting that Professor Spector identified this inequity in the statutory text and in a memo that she wrote at the subcommittee level suggested some potential statutory amendments.
Well, but the statute doesn't prohibit non-lawyer representation. If it does, it's only by implication and does not expressly prohibit it.
Yeah.
But it's pretty specific. You have a, right, like, see, it's all a matter of statutory construction, right? But you do have a clear difference between subpart A and subpart B. Of
Right,
that same
and I will
section.
also say that the Texas Supreme Court does have the authority to override a statute as long as they give notice to the Secretary of State that they've done so.
As long as it's procedural only, not substantive.
And arguably representation is.
So since I don't practice in this area of the law, what is the practice? I mean, if in a property code case or an eviction, you can go into county court and be represented by an agent. Does that mean that the agent will retain counsel, or do they serve as a representative, i.e. plaintiff, as well as the attorney in that type of case? Because I'm just thinking in terms of you got an apartment complex or several rental houses, and then you have a manager who represents the entity as a party, but they have a lawyer.
I can answer that question quickly and probably not go more than a minute, if that's okay.
Absolutely.
So an apartment complex in the justice court is typically represented by an apartment manager, who is pretty schooled in how to handle eviction cases. I think my guess, without knowing the intent, and that's one part. The second part is there are companies that have emerged that they are not lawyers representing landlords in eviction cases. And I think my speculation is that those businesses wanted the opportunity to appear in county court to represent their clients throughout the eviction process. That non-lawyer representation for property owners is only limited to the county court. So that's where I'm thinking that there was probably some belief that they had some knowledge, and that the landlords were happy with that because it reduces their costs. Otherwise, a landlord would have to, an entity would have to hire an attorney because an entity cannot represent itself, as you all know, in a court.
Thank you, Professor Spector. 1132, 2 minutes past when I said we break, so let's break. But let's come back at 11:45.
Can I ask that we come back at noon?
Harry's like, I'm going to be gone until noon.
Are you going to be gone until noon, Professor Spector?
Yes. I'd like to get to my office. I'm at home and I'd like to get to my office. I could be back by noon. I could be back on the screen at noon. If not, I'll stay. That's okay. 11:45. I can do that.
Hold on 1 second.
Is there something else we can do in the meantime?
That's what we're talking about right now. Yeah, that may require us to bounce around in the agenda such that Judge Massengill gives his presentation and we come back to us because he has a limited window of time today with us due to work-related conflicts. So if everybody is okay bouncing around on the agenda, that is fine from my perspective.
Well, I'm happy to come back and then I can be done and get to the office. So that would be okay too. Either way.
So 11:45 is okay with you now, Professor Spector?
Yes, that'll work.
All right, we will come back at 11:45 then.
Thank you.
She's unmuting us.
Okay, we are officially unmuted. Thank you very much. So welcome back to the meeting. I think it's become clear that for both the housing recommendations and for the consumer debt recommendations, some additional thinking at the subcommittee level is needed. However, there has been a question presented that I think would benefit from the group's feedback today. And it's whether to allow a licensed paraprofessional to represent residents in an appeal of an eviction suit for non-payment of rent in a county or district court. So in other words, it would be whether to expand what is permitted under 24.011B of the property code to allow representation of residents on appeal, but solely by these licensed paraprofessionals. So anyone want to speak against that? Going once?
Wait a minute. I'm generally in favor of it. I think that equalizing the playing field, it was the reason I raised that inequity in the statute originally. But I don't know that we have that the committee. I'm hesitant to speak for the housing subcommittee without more members here. And I think Karen is in the room. Because we're not all in agreement on certain things, and I want to make sure that the voices are heard.
That's so respectful, and I should have been clearer that what I'm asking for now is if there are any working group members, anyone present here who wants to speak against the proposal to allow licensed paraprofessionals to represent residents in an appeal of an eviction suit for non-payment of rent in a county court or district court. Understanding we may go back to the subcommittee, Professor Spector, and get dissenting views that we would bring back to the working group. But the question today is presented to the working group members who are present. All right, so now we have a sense for the working group's views, and I think we take that back to the subcommittee and revisit the proposals and try to put a little meat on the bones, if you will. But in that regard, I'll ask a similar question. Is there anyone who's present here today in the working group who wants to speak against any of the recommendations numbered 1, 2, and 3 on page 17 of the PDF? Okay, so I think we have a sense of the working group here, and we go back to the subcommittee and present to you something in a different form that you can vote on in more specifically in a rule modification form. Okay, so we will turn now to the family law subgroup recommendation, which begins on page 12 of the PDF. And again, this is precisely what was presented at the last working group meeting on July 27. It has not changed. It's being brought to the working group today to see whether essentially the subcommittee has approval to go forward with drafting rules in accordance with the recommendations from the family law subgroup that have been approved by the scope of practice. So open the floor for that. And I'll entertain a motion to authorize the scope of practice subcommittee to propose rules in accordance with the recommendations of the family law subgroup. If somebody wants to make that motion.
We'll have to make the motion with the.
Yes, because you're proxy.
Yes, I'll make that motion.
I'll second that motion.
There's a motion from Kim Wilson, a second from Karen Miller. Any discussion?
I just have a comment that I assume that the rule is gonna be, if you're gonna take this recommendation based on what a licensed paraprofessional could do without supervision, without trying to articulate in a rule what they can do with supervision. In other words, I just wanted to make sure that the rule as that is proposed does not distract from what we know paralegals may be doing now in family law firms across the state of Texas.
Thank you for that. Yes, that is the intent. Any further discussion? Okay, all those in favor of the motion say aye.
Aye.
Anybody opposed, say nay. And before we go on, I must ask if we have a quorum. Lonnie, are you present with us?
I am, yes. Can you hear me?
Yes.
Okay. Yes, I think we do. We have 18.
Great, we're good. Thank you. I just wanted to make sure.
Sorry.
Nothing stick.
Kevin does not want to revote.
Yeah. Okay, thank you very much. We'll now move on to the probate subgroup's recommendation, which begins on page 15 of the PDF. Again, this is precisely what was presented to the working group led by Craig Hopper in the presentation at the last meeting on July 27.
What page did you say? Sorry.
It's page 15 of the PDF. So if somebody wants to make a comparable motion about authorizing the subcommittee to go forward with crafting proposed rules in line with the recommendation of the probate subgroup, again, with that having been approved at the scope of practice subcommittee level, I'll entertain a motion. Nobody wants to.
I'm gonna make that motion. I mean,
Kim makes the motion. Is there a second?
I'll second.
Karen Miller seconds. Any further discussion? All those in favor say aye.
Aye.
All those opposed say nay. Okay, so we have marching orders. It's 11:53, and I do want to bring to everyone's attention that the scope of practice subcommittee has had some preliminary conversation about eligibility for receiving the contemplated services, but we have not yet delved into this in detail, nor have we taken votes at the subcommittee level. We did, however, have at our screens in our last meeting, a memo that starts on page 19 of the PDF, which addresses eligibility for contemplated services, specifically the issue of what does low income mean in this space. And so this is a preliminary question. It's separate from the question of whether you're going to require screening and reporting, and if so, what that will entail. But we do have 6 minutes before Judge Massengill's portion of the presentation begins. So if people want to provide their insights in terms of, in your own experience, the threshold for eligibility, that would be useful. I should say that what you see in the memo before you is part of what comes from our working group members and subcommittee members and other individuals involved with our effort who've reached out to community members. So there's already some input from some of us reflected in this memo, but if anyone wants to add anything beyond what's in the memo for eligibility, this is a good time to have a little preliminary discussion about it. Professor Spector.
Thank you. I've not reviewed that memo and the guidelines in detail, although I note that you do have the legal aid guidelines, which are pretty well circumscribed by federal law on the poverty guidelines and the LSC funding. Organizations like SMU and others who don't receive federal funding aren't limited by those very narrow definitions of what the poverty level is. And I would say that may be where some of the biggest gap is people who make too much to qualify for legal aid services by a legal aid agency, and those who make too little to be able to afford an attorney. So I would caution against using the legal aid guidelines as our strict definition and to use something more expansive.
Professor Spector, does your clinic or the clinics at SMU, do they have any guidelines for how you define eligibility?
We each faculty member screens their own applications. Some go strictly by the poverty guidelines. Some relate simply to someone receiving federal assistance, like Social Security benefit, looking at their source of income. We all make exceptions where it might be, I can't think of any at the moment. We all try to adhere as best we can to providing services to those who tell us they can't afford them with some evidence of that. Sometimes we may ask them to go try to find a lawyer and try 3 people who say they won't take the case before they come to us. But we also represent clients who certainly would not fall within poverty guidelines, those who are starting a business, who are seeking a patent, but still are needing legal services of some kind. The short answer to your question is I don't have a formal policy document.
And one of the reasons I've included in the memo dollar amounts is because sometimes I think people hear percentages and it feels really big. You know, when you're like 200% of federal poverty guidelines, 400%, it sounds big. But I think it's important when we're thinking about eligibility to think about what it means in terms of dollars. And so I encourage everyone to look at the charts that are provided in the memo so you can see the breakdown of the different percentage points. Because I think it can change your mind in terms of what you're thinking with the particular standard. Karen, was there something you wanted to say?
I was thinking too what Professor Spector was talking about, and maybe one of the other approaches that we might consider is people who would qualify for an affidavit inability to pay
I was
costs.
thinking the same thing.
You know, there's some automatics, if you're receiving public benefits, that you're automatically entitled to that fee waiver. And that may be an easy delineation,
That's a good point.
Yes, I think that's true.
a little broader than our legal aid and grant restrictions.
Right, and one point made in the memo, but worth stating out loud is, of course, to the extent that these contemplated licensed paraprofessionals have some sort of grant with funding restrictions, those restrictions would have to be honored, right? But we're talking about outside of that scenario, what's the standard? And you're right that the affidavit of inability to afford court costs is different, but does, I think, a nice job of capturing those individuals who truly can't afford to pay the costs along the way. At least I've seen that play out in my pro bono cases when I've had to help people fill it out. Kim?
But aren't those, and I'm gonna devil's advocate just a little bit, because I don't think, because usually when we're representing people pro bono with those affidavits, that it's coming from a legal services organization oftentimes, where they've already qualified financially for their assistance, even through their volunteer pro bono attorney program. So there's still a financial descriptor of eligibility, and just the statement of inability to pay is, it doesn't really have a bright line test, because it's judge by judge to determine that.
Well, he doesn't have discretion in certain areas, so
Right.
if you're getting public assistance, or you are in a legal aid
Mhm.
program, you don't have discretion.
Right.
But there are people who are not in the legal aid programs who, if they check the box that they are getting public assistance, a judge has no discretion to grant that. He has more discretion if you can't check one of the boxes. He can still say, I don't think you can pay, but the judge, you know, there are certain criteria in there broader than maybe legal aid qualifying that would allow a judge to say you were unable to.
That's a good point.
Yeah.
And I have noticed that I've had some individuals I've helped pro bono who came through VLS and some who didn't,
Mhm.
and I still was using that form.
Right.
And so I think they do a nice job in terms of trying to assess those individuals who truly can't afford to pay, but also having a check in the system such that if there's a determination that no, in fact, you can pay, they don't get to move forward without payment. Now, whether that's the same standard to be applied to representation by qualified paraprofessionals is a related but different question. But it's worth considering very much so, I think.
And I think that it seems that someone who's on public assistance, and I can't speak to what that requires from their income, I'm not familiar enough with that to know, but would be one of the qualifying criteria, but also I know that there are probably lots of people that might qualify for public assistance that don't seek to obtain it, but would qualify from an income eligibility. And I think about reduced lunches and free lunches at school, and I know that schools, it's a little moot right now, but it's, there are lots of students who would be eligible for free or reduced, but don't apply because their families don't want them to be perceived as poor, or don't want their children to be singled out. So I think that there's some benefit to talking about also financial income. But I agree with don't get crazy with 200%. 200% of the federal poverty column for a family of four is $60,000. Even in Stephenville, Texas, you can't live very well on $60,000 for 4 people. You certainly can't.
Right.
I'm assuming.
Yeah.
Yeah. So that's the other problem too. I think there is a difference in what someone in a rural area might be able to afford and what somebody in a metropolitan area might be able to afford. I'm not suggesting that we go down that path at all. But it is a consideration. So from my perspective, 200% would be good, but for yours, 300 might be better.
You know, that's interesting too. I'm not well steeped in this, but recently became a little more familiar with the HHSC standards for rental assistance in different communities, and it varies by community how high it can go because of the cost of living is different in various places. So that may be a table that would be interesting to look at.
That is a good.
It's I'm sorry, this is Paige. We have some grants that we actually use AMI, adjusted median income for the area. IRS sets out, you know, what the median income is for the area, and then we qualify people that way.
This is Ellen. I was gonna say that I agree with what everyone's saying, and I would certainly prefer it be broader and something that is more inclusive. As you point out, you know, even with the 400%, I'm looking at this 400% for a family of 4. I mean, 120,000 sounds like a lot of money, but it's not, depending on where you live and depending on your circumstances. And it doesn't take much for a family to have their income greatly affected by, say, an unexpected car repair bill that's very large, or an unexpected medical bill, or someone who's unable to work for some period of time. It does sound like, from what everyone's saying, it would be useful to have several criteria under which people could qualify. So, because as you mentioned, and I'm sorry, I didn't catch who it was, but I agree that not everyone who qualifies for aid actually seeks it. And so you may qualify, but you may not be able to show that you were receiving any kind of federal or state aid. So certainly having more options for people to qualify would be better, I think, than fewer.
Thank you, Ellen. Professor Spector, we'll take your comment or question, and then we're going to shift gears because we have Judge Maciel in with us to give his presentation in his limited window of time. So Professor Spector.
There is another provision of the government code that authorizes a county court at law judge to appoint an attorney for a tenant who requests one by filing an affidavit of inability to appeal, an inability to pay costs on appeal. So that is what that affidavit is used to secure a free lawyer in certain circumstances, and it might be worth looking at as one of the factors in making a decision.
Thank you, Professor Spector. Is that the property code, I'm sorry, the government code provision that was referenced in your memo?
Maybe.
Okay. We'll talk offline.
Okay.
Thank you so much for that discussion. It was so enlightening. And I think we have some good guidance as a subcommittee moving forward. So thanks very much to everyone. And now I'll turn it over to you, Judge Maciel.
Okay, I hope you can see me.
We can.
More importantly, I hope you can hear me.
Yeah.
I will not bother trying to change my Zoom name from Houston Zoom Cart 1, but I'm Michael Massingale, and I'm very sorry I'm not with you in person. As you can imagine, it's challenging to coordinate all of our schedules, and I had hoped to be there, but I'm here. I caught the tail end of what you were just discussing about income eligibility. I'm so sorry I haven't heard everything that's already been discussed today, and look forward to catching up with Kenan and Lisa and watching the recording of what's been discussed. But I'm going to be presenting about the work of the non-attorney ownership subcommittee. And I feel like we've made really good progress on substance of a proposal that we look forward to being able to propose to you for hopefully for approval in a more fleshed out and detailed way when we meet again in November. But I think we've made very, very good progress with some work still to be done that I'll spend a minute talking about later. But very, very eager to get your feedback today, questions today, because as I'm sure has already been mentioned during this meeting, we'll be working after this meeting to bring you, a proposal that we hope to have approval from you when we meet again in early November. So let me first give an overview of where we are on our proposal. If you had a chance to review the materials that we circulated in advance, I do believe it gives a pretty comprehensive overview of what we've been discussing, as well as, for those so inclined, a roadmap back through all of our work, minutes and materials from our meetings. So all of that is there for those who want to dig in deeper. And if I can ever be of assistance pointing you towards material, I hope nobody will hesitate to reach out to me. We have at all times had the particulars of the Supreme Court's charge very squarely in our focus, and it has guided our work and the kind of proposal that we understand the court to be asking us to develop and propose. From the outset, let me say that what we are working on is a proposal for a pilot program of some kind. This is a detail that has not been one that we've fully run to ground, but the court asked us whether it should be a pilot program or a regulatory sandbox, which is the terminology that's been used in Utah. Whether there's even any important substantive distinction between those, at this point, candidly, I'm not sure. But what is important is that what we understand to be ourselves to be proposing is an experimental program, something that would be instituted provisionally so that there would be an opportunity for the court and for the public to see how this proposal plays out in practice, gather data and evaluate the data, and further evaluate in the future whether it should be changed and whether it should be formally implemented in a more permanent way. An important part of accomplishing that is thinking about how it will be administered. And to the extent there is some necessary regulation, who will be doing that? So that has been a topic that we've devoted a fair amount of consideration to. Among the various things we've considered, the Office of Court Administration seemed to be a very suitable candidate. And as we researched further, the Judicial Branch Certification Commission, which is a formally, legislatively authorized body that serves to implement regulatory programs that are proposed by state law or specifically by the Supreme Court. This is an existing regulatory body that has a pre-existing framework with express statutory powers and authority that we have identified as a very likely candidate to serve the needs of implementing a program of the type that the courts described to us and that we have been working to develop. Just to give a quick thumbnail sketch, the commission itself, and we're lucky to have Judge Harrell, who's the chair of the commission, as part of our working group. But the commission is appointed by the Supreme Court. It regulates some other court-adjacent professions, such as court reporters and guardians. But importantly for our purpose, it's got all of this infrastructure that's already there, both from a statutory standpoint and also rules promulgated by the court. And I think importantly for our purposes, it's a structure that will allow the court, as this program goes forward, to maintain a degree of control through rulemaking and make changes over time that may be desirable or necessary. So if there are questions about that, we can talk about it in the discussion period. But I'm going to move on now to talk more about the substance of the proposal. But I think you'll see that knowing where it's going to be housed and who's going to be regulating it is a helpful starting place. So what we have been discussing as a way to satisfy the court's charge is creating an exception to most of the substance of Rule 5.04. And this is the rule that in 5.04D prohibits non-lawyers from having an ownership interest in for-profit firms that provide legal services. In other relevant parts, it also prohibits certain kinds of sharing of attorney fees with non-lawyers and in certain types of business structure. So we start from the premise of we're creating an exception to those otherwise applicable rules. And the purpose of the exception, and this is something that we take great pains to always keep front and center of our consideration, is that we are looking at the opportunity to enable new and innovative ways of delivering legal services, particularly for the purpose of expanding civil access to justice in areas that are needed by low-income Texans. And so, by carving out an exception to Rule 5.04, we hope to create a regulatory carve-out where people who want to bring innovative ideas to the legal market, like RASA, which I know we've discussed in the past, which has an innovative online platform for helping people to obtain expunctions, creating a regulatory carve-out that enables that kind of innovation. How would it be achieved? We have been talking about two tiers of rules. And the high level first tier of rule would be whatever rule establishes the exception to Rule 5.04. It would generally describe the fact that we're creating an exception to Rule 5.04. Our focus has been on entity-based approval of entities that would make application for the privilege of offering legal services and operating under this new provisional exception to Rule 5.04. The top level rule would make clear that the purpose of the rule is to expand access to justice for low-income Texans. It would describe the basic parameters, which is that for entities that obtain certification by the Judicial Branch Certification Commission and are also licensed to do so by the Texas Supreme Court, and this is important because the court has exclusive authority to issue licenses to practice law, that an entity that has met these qualifications will be permitted, apart from the otherwise applicable rules of 5.04, to provide those legal services that it has been approved to provide. So it's important because the entities approved to operate in the pilot program don't get to provide any legal service they want to. They get to provide the legal services that they identified as the services that they intend to provide, and that they have been approved, specifically approved to provide when they were certified by the JBCC and licensed by the Texas Supreme Court. We also contemplate that at this top tier of rule, it would be contemplated that this is going to be, this is going to require ongoing reapproval for the firms that obtain permission. So the rule very expressly contemplates that once initially approved to provide legal services, that there's going to be an annual reapproval. And so a built-in check, an opportunity to revoke permission to firms that, for whatever reason, are not viewed as satisfying the purpose of the exception, which again is to expand civil access to justice for low-income Texans. So that, I think, covers most of, and in the materials, I guess I'll quickly share my screen, but the materials contain language that sort of we propose as, you know, our current state of proposal for describing that top tier of a rule that creates an exception to 5.04. And happy to get any comments, suggestions about that phrasing. I know it's a big block of text, but that's the important framework. Then we contemplate a second tier, and this is also very, very important. So for those entities that receive permission to provide the services that otherwise would be prohibited by 5.04, there will be a process that will involve an application, approval, and then reporting and continuing oversight. So at the stage of seeking application, and all of these aspects of sort of finer aspects of regulation are an important way by which the JBCC will be able to calibrate the program and ensure that it's being used for its purpose, which is to expand civil justice for access to justice for low-income Texans. So we have proposed a number of elements that should be required parts of the application process. The entities seeking permission to operate in this way would have to describe, as I mentioned earlier, you know, a specific scope of legal services. And if they're not legal services that there's a need by low-income Texans for, kind of by definition or by rule, it would be ruled out. I think this is important because this part of the rulemaking likely would exclude a lot of the more problematic possible types of practice that people, you know, think about when they think about concerns they might have about this proposal. So it's if you're proposing something that clearly nobody who's a low-income Texan is going to need, it's not the kind of thing that this exception's been created for, not the kind of thing that we would expect to be approved. We would also expect that the intended client base would be identified, how these services will help to increase access to civil legal services that are needed by low-income Texans. We'd expect them to describe the proposed fee structure, what's your proposed engagement agreement, what will be your ownership and management structure. So we'll want to know both for screening purposes, but also for collection of data. You know, we're going to want to know who the owners actually are, and who the managers are. And in specific response to one of the requirements of the court, we would expect them to specifically address in writing the protections that they intend to implement to protect lawyer independence, to ensure that the lawyers working within this entity can satisfy their ethical obligation to their clients, and provide independent legal advice that is not unduly influenced or interfered with by non-lawyer owners or managers who may have interests other than simply providing independent legal advice to a client. And then some other things that we propose to be required disclosures would have to be addressed. For example, whether the entity is going to maintain any kind of malpractice insurance for its legal services, information about how to report complaints, and the JBCC does have already have an established complaint process, but we would expect all of this to be incorporated into an application process to facilitate review and consideration of whether to permit those services to be provided. We also propose that these entities would have to undertake a number of ongoing obligations. One that many people express concern about is whether these entities will operate in sort of a separate universe that is free from the kinds of ethical constraints that lawyers traditionally operate under. And we do not propose to create that kind of scenario. Instead, what we contemplate is that the legal services would have to be provided subject to the same ethical constraints that apply to lawyers, and that there would need to be an identified lawyer who's responsible for ensuring compliance with that. And the identification of that person would have to be shared as part of the application process. We also anticipate that we would want, if for no other reason than for study purposes and future evaluation of the effectiveness of the program, that there would be required collection of data about clients, about the types of services provided, about the effectiveness of those services. We would expect that to be gathered and shared so that both the entity can be reevaluated and the entire program as a whole can be evaluated. So once that application has been made, and the current phrasing of the proposal that I shared a second ago is informed by the phrasing of the statutes and regulations for the JBCC, but we contemplate sort of the main vetting stage would be performed by the commission, culminating in a certification of the entity to provide the specified legal services. Then, as the proposal is currently written, we do contemplate sort of a further step, possibly a ministerial one, but an important one, where those certifications would be passed on to the Supreme Court to issue a license for these limited specified legal services to be provided. And we can get into it now or later, but I think this is a desirable additional step to take account of some of the statutes and rules that exist prohibiting the unauthorized practice of law. In effect, we intend for this proposal by the Supreme Court's implementation by the Supreme Court to transform these legal services from unauthorized to authorized practice of law. And I expect we'll be in continued communication with the rest of the groups, the other subcommittees about these sort of finer points of authority, but that is the working framework of this proposal. And as I said, we anticipate that the approved entities would then have to seek reapproval or recertification on an annual basis. One other thing that that I haven't yet mentioned, and that is an important part of our subcommittee's work and part of what we still will be working on, is that I think this second tier of screening is also an opportunity to take account of more specific types of concerns that may exist for particular types of legal services, particular forms of delivery of legal services or billing methods, or concerns that may be specific to particular types of practice. One example I will give you is contingency fee litigation. I think in our discussion, there's a sense that contingency fee litigation already exists to make legal services available to people who are unable to pay for them. And there's not a sense that opening contingency fee litigation to non-lawyer owned entities would do anything to materially expand access to justice in that respect. So that may be a good reason why you just would rule it out. That's not something that is going to be approved. With respect to practice areas, we have gotten very good substantive input from a number of lawyers representing different practice areas. We've provided you the written reports we've received from the tax section and the immigration section. We have on our subcommittee a past president or past chair of the family law section who is engaged with our work. And we are actively involved with all of these parts of the bar to better understand how this proposal might have unique application or perhaps challenging application for their practice areas. And I think that we have identified genuine opportunities to pass on, as part of our proposal, suggestions that there may be reasons to carve out or limit specific aspects of these areas of practice. So I have, as I mentioned, this is something that we are in ongoing dialogue with these representatives of the different groups. Because of the nature of it and our timeline and the fact that, even if this is ultimately adopted and implemented, we know that there will be future process, future, further consideration of rulemaking considerations, and whether it's the JBCC or some other group in the future, somebody's ultimately going to be making final decisions about these rules and regulations and guidance that will be provided to those seeking to provide these types of services. So at least I have not felt heavy burden to, given our timeline, to reach full conclusion of every nook of potential guidance that we might want to ultimately provide about these practice areas. But I'm confident that we will, at a minimum, be able to get the ball rolling and identify some of the concerns for a continuing dialogue as we explore this going into the future. Hopefully, give the court the benefit of that work that we've done. So I want to give everybody an opportunity to ask any questions or share any feedback. Let me just mention that in terms of our kind of what's remaining to be done to give you something that's more concrete that would be in the form to approve. One area, of course, is what I was just discussing, which is that we want to run to ground as best we can these discussions that we're having with practice areas, particularly it's tax, immigration, and family who have engaged with us. But our door remains open to any other lawyers who want to reach out to us. We've had some very interesting discussions about the mechanics of protecting attorney independence. We've got the benefit of some true subject matter experts on our subcommittee, including Professor Susan Fortney and Professor Renee Jefferson, who I want to acknowledge for their really valuable input on the subcommittee. The state of our discussion there is kind of more a discussion of options, and we need to hone in a little more on an affirmative recommendation, which we'll be doing. And then the last thing, and it's not a small thing, but I've left it to last because it's not been a focus of sustained discussion in our subcommittee. And that is, we've gotten feedback from some groups of lawyers that they would like to see some facet of means testing or income eligibility built into this part of the proposal. We are committed to having some continuing discussion about that. I think it's not a foregone conclusion that that should be part of our proposal. And we had some really interesting experience shared with us in the context of RASA about how it is that being able to make the service available beyond just those who might fit a predetermined criteria of income or means might be an important facet of how these kinds of innovative services can be brought to the market. And so I think we need to think carefully in this area about, what's the motivation and the true purpose of putting those kinds of restrictions and constraints on innovative proposals that have the opportunity to truly help people. But we'll have that conversation, and I imagine that conversation will continue beyond the recommendation that we make in November. So I think I've covered it, and I really want to thank everybody for your attention to this. Ask you to please today and going forward share any thoughts that you have, and would be thrilled to get any of your feedback today or answer any questions people might have.
I have a question. In our discussions in the scope of practice, I think there were limitations placed on paralegals to say they could not be directly paid by the client. And so I'm curious how that would impact having an entity that is charging people for services, whether or not, if the committee agrees to go this way, or the Supreme Court agrees to go that way, then would we have to eliminate the restrictions saying that paraprofessionals paid by the client?
Good question. Is that Richard?
Yeah, it is.
Hi, Richard. It's a little hard for me to see, but it's good to see you there. So it's an interesting question about sort of how some of these parts of the bigger project are going to overlap and interface. And I'd love to get the reflections of my co-chairs on this as well. But my initial reaction to you is that to the extent that there are restrictions imposed on what on the expanded scope of what paraprofessionals are permitted to do, there may be a way for a firm that is seeking certification to provide legal services in an entity that has non-lawyer ownership. There may be an opportunity for a firm like that to also take advantage of employing paraprofessionals who operate within the expanded scope. But as far as I'm concerned, and as far as my brain can fathom at this point, those paraprofessionals would operate under the same constraints. So it's not like being in the entity would somehow negate a restriction that applied to a paraprofessional through this other part of our proposal. And so if that means I think it means that these entities, like anybody else, would have to take into consideration, if they want to use the paraprofessionals, you know, there's criteria and circumstances under which they may or may not be able to perform a service. Is that responsive, Richard?
So sort of, so my understanding is that using non-attorney run organizations would be to hire lawyers to do certain tasks as opposed to paraprofessionals. Like the one example, maybe, but early on, I think in Utah, there was some IT company that was financing function clinics. And so was that legal work being done by lawyers or paraprofessionals? I could see a paraprofessional doing it, and not necessarily a lawyer.
Right. Well, so I do think that clearly our proposal would be a proposal that would facilitate hiring lawyers to deliver services, and maybe that is the primary way that it would happen. That would make sense to me. And then the question would be, is there an opportunity for paraprofessionals to also operate within this structure? In the abstract, I would say I can't think of a reason why not. Now, if in the context of the paraprofessional proposal, it's thought, if I heard you correctly, if there's a thought that that no part of a fee that pays for the services of the paraprofessional should come from the client, if that's part of the proposal, then I would think that'd be a constraint on the entity. I guess I'd also suggest, though, that maybe you might want to consider if the paraprofessional, the opportunity for a paraprofessional to deliver a service in the context of a for-profit firm that's been certified by the Supreme Court to provide a service that would be of use to low-income Texans. Maybe we don't want these firms that have this permission to have that constraint. Maybe they should be able to use paraprofessionals. So I think these two projects should be informing each other. But I think if there's a reason for the restriction you're proposing, and if it's adopted, that the firms operating under an exception to 5.04 would have to accommodate it.
I have Justice Massengill, this is Kim Wilson. I'm actually Jonathan Bates today.
Okay. Hi, Kim.
He's much prettier. But I do have a few questions, and I start by saying I really appreciated the thoroughness of the information provided to the working group. It was very helpful to me, especially as the proxy. And these may be covered, and I apologize if they are. I did read it, but maybe not every single word as I could have. One question that I had is, do you anticipate, have you all discussed any requirement that a Texas licensed attorney be part of the ownership structure or have a particular percentage ownership in the entity in order to maybe ensure compliance with licensing as a more, if I'm gonna lose my license to practice law, I might be more interested in making sure my entity follows the rules than I am if I'm not licensed to practice law in Texas anyway.
We haven't specifically talked about that kind of a requirement. I think it's worth thinking about. What we have discussed is that you would have to, in fact, have a licensed Texas attorney who is employed by the entity and is given the responsibility for within the entity ensuring compliance with all of these undertakings that the entity would be required to make in order to get the certification to provide the service. You would have to have an attorney to do that, and that person would have to be identifiable. I would think identifiable both to the JBCC at any time and perhaps also to the public at any time, so that that concerns can be addressed to a licensed Texas attorney working within that entity. Whether requiring that an attorney have some piece of the ownership or a specified percentage of the ownership, we haven't discussed. My general reaction is I'm not sure you would want to discourage, on an ownership basis, people who aren't lawyers, if you buy into this idea in general. But I think it's a good suggestion for consideration. And as I said, this is something that is on our list of things to continue discussing. So I see Craig's got his hand up, but Kim, did you have something else?
Craig, do you mind if I ask my next question?
No.
Go for it.
Okay. My other question was, you described that you expected the JBC to determine to review and approve the applications. Do you anticipate that the JBCC is going to determine whether or not what the appropriate legal services to be rendered are, or are you going to propose, is your group going to propose a list of legal services that it must fall within?
Right.
About,
Sure. Okay, so let me address that in two parts. First of all, I think as we've kind of put it on paper and we've been discussing it, the idea is first, the entity seeking approval would have to specify, particular services they propose to provide. And then as part of the review process, they could be authorized to perform the same scope that they propose, or they could be, required by the JBCC to prune it down. I wouldn't assume that it's a binary up or down. I would contemplate that there is an opportunity for some consultation and back and forth in the process of applying and obtaining certification. Now, you also asked about should or would there be a pre-selected list of services, and I think the court's charge did contemplate considering this, and I have thought about it. I don't know that we've formally taken it up in our subcommittee, but my general reaction to it is that it's a little bit at odds with the whole motivating idea that this is intended to unleash forces of innovation. And if we just haven't had the vision to foresee what somebody else can propose, and therefore it would be excluded from the outset because it's not included on our list, I think would not be consistent with our purpose. Now, maybe you could say, anybody would always have the opportunity to come along and say you need to expand the list, and that's fair enough. But my own thinking about it, and certainly we've not come to any final conclusion, but I think it's better to have an open door to let people who are creative and entrepreneurial and have an idea that could help people bring us the idea and then vet it for problems, rather than try to anticipate what they would be and require that they fall into certain categories in advance.
Thank you.
Thank you. Craig?
Well, my question was generally about some implementation issues. So have you had a chance, Justice Messenger, to speak with anybody from JBCC about this maybe being added to their plate?
Yes, we have engaged directly with the head of OCA and the director of the administrative director of the JBCC. They have both confirmed that, and they have seen our proposal, and they were part of our last meeting on this subject. And the feedback we have from them is essentially they don't see any reason why it can't be done.
And so what they would do is they would create a new advisory board section for this, as they do for the other 3 or 4 issues that they deal with.
Yeah, sure. I can say a few more words about this. So yes, Craig is right that one thing that exists under the JBCC structure is there are distinct advisory boards that advise the commission on the various elements or the different types of groups that are regulated under the JBCC. And so, yes, I would expect that there would be an advisory board specifically for this new project that would be added under the umbrella of regulatory projects assigned to the JBCC. We have already talked a little bit about staffing and funding, because those are important considerations. There's a statutory feature in the JBCC that I don't think it's a huge obstacle, but it's something that may not be an issue if we were to house this regulatory authority somewhere else. And that is that the statute requires that the JBCC be self-funding through fees. And so we've had some discussion about the fees that are charged by the JBCC. Obviously, it's the whole purpose of what we're doing is we're trying to clear the way for people to lower the cost of services. And so a regulatory fee works against that. But I don't think the amount of the fees currently charged by the JBCC are such that they would be likely to impede somebody who's got a proposal for innovation. We anticipate that there would be a need to employ a few more people to do sort of the kind of the close to the ground work of evaluating the applications and making recommendations about them, and then on an ongoing basis, collecting the data and interfacing with the various entities. So all of that would require some additional staffing. But at least so far in our discussions, it's not seemed to anybody to be anything that would be insurmountable or fundamentally inconsistent with what JBCC is already doing.
Well, because now they certify individuals generally for things like guardianship.
Yeah, I think that's fair.
Doing it for an entity is what the question.
I think in that respect, this is slightly different, but I ran, Lisa Hobbs and her subcommittee have been engaged on JBCC, a few steps ahead of us, and to the extent that I was trying to stay up with Lisa's work, I had learned more about the JBCC than I had previously. But it wasn't until I started talking to OCA directly that I realized what a good fit it appears to be for regulating here. And to the point you're raising, Craig, I went and I read all those statutes, and there's nothing in the way any of that is phrased that I see to support a distinction between regulating an individual versus an entity. If I had seen anything like that, and if anybody else is aware of something like that, I certainly want to surface it, but I have not come across anything like that.
I guess we're anticipating that we would need to codify something into the government code, for this specific.
I don't think so, because the statute, and I've given the citations and some links to the operating rules are in the materials we provided. But one thing that I love about this from a standpoint of just sort of making sure that there's authority for what we would be suggesting that the court do is that it very clearly, the statute very clearly gives the Supreme Court authority to assign regulatory programs to the JBCC. And so, you know, there's a pretty solid and broadly phrased kind of foundation of authority there. And there's, as I say, I have not found anything in the more detailed parts of the statutes or rules that would, you know, would exclude an entity from. I see a hand raised. Is that Lisa?
Yes.
Wow.
Everything that you said is accurate of my understanding of the JBCC. But I also want to add, just to Craig's good comment, is that the JCCC does currently do entity regulation as well as individual regulation. So the concept of entity regulation is foreign to that particular commission. I know they do court reporting firms, and I believe that guardianship entities also can be an entity and not just the individual.
Thank you, Lisa. Yeah, I'd forgotten that, but thanks for reminding us.
And Lisa, you may have already looked into this, and I don't know how this sausage gets made, but I can see that it seems like there are chapters in the government code for each one of the things that they certify and continue to monitor. So, but it sounds like maybe there's a way that we can avoid having to amend or having to create a new statute.
I think Michael can address that.
I'm sorry, what'd you say, Lisa?
I think you can address that.
Yes. So the way I read it, the way, and I don't have that statute in front of me, I'm sorry, but the provision I was referring to, it refers to both state law and the Supreme Court assigning projects to be under the JBCC. And so the fact that there are statutes, you know, that support some of these other programs, I think is fully consistent with this statute, because it's separately, it's a state law or, you know, the Supreme Court. The Supreme Court, I mean, this, my read of it is the Supreme Court is authorized to assign a new regulatory program to be administered by the JBCC.
Well, that sounds good. I saw that there were those extra chapters, so I didn't know if we'd have to jump through that same.
No, and maybe down the road, if it gains acceptance, maybe there, you know, the legislature would be moved to enact something like that. But we're not there yet. So I saw Professor Spector had a virtual hand up.
No, I did not. Thank you.
Oh, not intentionally. I don't know if anybody else has had this. I think they added something to Zoom. I in the last couple of weeks, I noticed I just did my hand like this on my screen, and then the orange hand appeared in my corner.
Yeah.
It's not happening where I am right now.
I have a hand up.
Okay, I can't see who's waving at me though.
Erin Miller.
Hi.
I'm curious, I appreciate that there would be a recertification on an annual basis. But this kind of makes me think of some of the applications that I've applied for with grants, and some of the, you know, applications are inviting innovative approaches. And some of the grantees sometimes have such innovative approaches that you get a little bit into the practicality of doing it. And it turns out real problem.
I'm sorry, I missed one word. The practicality of what?
Doing those innovative approaches, like once you get started, you realize, oh, we didn't think about that. And there's a real problem with it. And I've seen grantors pull the plug on those grants before the end of a grant period. And often it's, you know, because there's been egregious behavior on the part of an entity that was doing something. And so my concern, particularly the approach of this model is that someone's making money off of it. We're trying to ensure that low-income people are being protected. I wouldn't want I would feel much more comfortable if there was monitoring of that. That there would be, but the ability to pull that license or certificate prior to the end of.
Well, so I think a lot of what you're describing are reasons why we have taken care to specify that we want there to be reporting and we want there to be evaluation. But let me speak to sort of the broader point about a profit motive. And I certainly sympathize with how that is a different approach than many of the people who are involved in this project are people who have dedicated their careers very selflessly to helping low-income clients through legal aid and pro bono and nonprofit and all kinds of ways that are more altruistic in nature. The fact of the matter is what we are talking about, the only reason you would even need an exception to 5.04 is if you were talking about a firm that was providing the service for profit. There's generally not anything stopping Texas law firms today. I mean, there is nothing stopping Texas law firms today from looking at Arizona and Utah and seeing an idea that they want to bring to Texas and provide under a traditional law firm model. There's also nothing that would stop a nonprofit entity from, starting up something like RASA in Texas. And if we saw that happening, maybe there would be a strong argument to say we don't need to facilitate innovation in Texas because we can just watch and see what innovation produces in other jurisdictions, and then somebody will see that's happening and provide that same service in Texas under one of our pre-existing traditional modes. But I don't think we're seeing that happen. I don't think we can sort of assume that that's what would happen. And so, I think there are reasons why a firm that is fundamentally operating for a profit motive need to be watched, especially kind of at the provisional and experimental stage of this. But if we say we're worried about the profit motive, I mean, there's going to be a profit motive by definition in anybody who's looking to take advantage of this proposal, because if there's no profit motive, they probably don't need this authority.
I think that my bigger concern is sometimes these innovative approaches aren't taking into consideration all of the things that traditionally we've done to protect these are more particularly vulnerable consumers. If they're spending money, more likely than not, and I've worked with these people all my life, more likely than not they're giving up something else. So if they're spending any money towards that, they're far more vulnerable than the general population. And traditionally, they've been able to find these services. We have to do, I believe. And so if something's happening, not protecting them, and I don't know what that is.
Yeah. I mean, I'm all in favor of building in oversight and protection and anything we can do. And somebody needs to give me an example other than RASA, because I feel like I'm the biggest RASA stan now in the state of Texas. But I hear what you're saying. I mean, we've talked about the fact that assume we had the RASA model in Texas. Well, for some people, the $12 to find out if you have criminal convictions that are eligible for expunction is a hardship. And the $500 to get them removed is absolutely a hardship. And we can all acknowledge that, but I think you also have to acknowledge that because pro bono and legal aid and all the other ways that we try to get services to the needy are not filling the need, if how can we deny the benefit of having another service available that somebody, I mean, $500 may be a hardship, but the idea of going and hiring a lawyer by the hour to obtain those expunctions may just be completely out of the question. And I also remind everybody that even in the RASA model, what we learned is that many people don't pay anything at all for RASA or get a discount on the RASA service because RASA obtains grants and RASA has opportunities to provide its service for free or at reduced cost to those who can't afford to pay for it. And so it's something to keep in mind that, you know, even within a model that contemplates charging for a service, there may be opportunities to effectively price discriminate and still charge a certain fee to people who have the means to pay that helps to, helps to sustain the service to make it possible, yet provide the same service to others who can't afford to pay either for free or for a reduced cost.
Justice Massengill, do you anticipate then part of the eligibility to require these organizations to have a particular percentage of service to low-income Texans, or not at all?
We have not talked about quantifying it in terms of percentage. I think it's worth thinking about. I think it also might be hard going in before you bring your service to the market and make it available to know or make a commitment or representation as to what it will be. You know, I've thought about this a lot. Let's just take an example. Let's say somebody brings a RASA type service to a proposal for a RASA type service in Texas, and they, as part of their proposal, they say, we're doing this because we know that there's a need to eliminate or to get expunctions, and we want to provide this. So let's say they come to the market. Let's just assume the RASA model that they're charging people $500 to obtain the expunctions. And let's also assume that, like RASA, they obtain some grant money that enables them to provide the service to some needy people for free. If it were the case that they were able to serve every person who could not afford to pay and provide it for free, and then they still were able to also provide the service to every other comer at $500 a person, and you look back at it and it was 80% for fee and 20% for free, do you look at that and they say, well, it was 80% to people who were not low-income Texans? Or do you look at it and say, they provided that service to every low-income Texan who came and needed it and was served by it? I don't have the answer to that question, but if we're putting first the needs of people who can't get legal services, I don't think you can disregard the benefit that would be given to the community by that program if that's how it played out.
Well, I would just say sort of respectfully that if we're going to approve these organizations on the basis of the legal services that they would provide to low-income Texans, but then we don't have an eligibility requirement for them actually doing that, that seems problematic. I mean, I'm going to take Hello Divorce, for example, because actually that model is what started me on this access to justice sort of passion to think about, because I met the a lawyer, a California lawyer who started Hello Divorce. And part of her whole philosophy was there has to be an easier, cheaper, and I'm gonna use the word cheaper, but less expensive way for people to get divorces, especially when it's not contested and not, when they just want to get divorced and be rid of each other. And I'm a family lawyer as well, and I found it very interesting. And and she is partly in Texas, and I'm not really exactly sure how they're doing it in Texas yet. But one of the things that I could see would be advantageous would be to develop that kind of program because it's very tech-based. But on the other hand, they also have to serve the low-income Texans. And I'm on her website, and it's $1,500 for the beginning plan. Well, that is not low-income Texans serving particularly. So how are we going to make sure that we're allowing people to create these organizations, but we're not requiring them to actually serve low-income Texans? And that, I think, is sort of to the point of maybe Karen's question a little bit of where do we guarantee or make them show us that they're doing the work that they said that they were going to do?
Sure. Let me respond to that. It's a great question. I appreciate it. Let me first say that divorce is an area that presents unique considerations and may not be the best kind of example for discussing it generally. I think, and we've been in discussion. We have Chris Nicholson serving on our subcommittee, and I know he's in touch with a lot of others in the family law community. So we're thinking carefully about what we might say that's unique to divorce scenarios, and I think they merit special consideration. That said, the way we've phrased our proposal so far is not to say that every client must be a low-income Texan, but that the entity actually provide services that are needed by low-income Texans. So to take your example, I don't want to pass any specific judgment about the amount of the fee that you mentioned for Hello Divorce, but I do think that under the way that we've structured it so far, something that the application process and vetting process would include is if somebody came and said, this is a service that is needed by low-income Texans, and our price is cheaper than traditional law firms. We're going to charge $1,200. I could imagine that alone could be a basis to say we don't think that this service as you're proposing it with this fee structure is really aimed at helping low-income Texans because of the amount you're charging. Now, how that would be administered, where you draw the line on fees, things like that. Fee between the $500 that RASA charges and $1,200 for Hello Divorce or some other amount of fee. To me, this is probably a regulatory detail that is going to ultimately, be, it's going to be something that's going to have to be decided, perhaps ultimately arbitrarily, by the people who are going to put the final rules into place and be charged with administering them. But just to go back to the bigger picture, though. We have, as it's phrased so far, we have proposed a process that would not admit of any possibility of authorizing firms to provide services that were not actually used by low-income Texans, and that was not, clearly a benefit to be derived from authorizing that firm to operate and offer its services. It's a separate question of whether and to what extent you would want to say this firm only can provide a service that would be of benefit to a low-income Texan, and as I've mentioned, we are still engaged in that conversation. I think that there's a compelling reason to say that we shouldn't impose those kinds of restrictions. But it's an ongoing discussion, and so we're discussing it.
Thank you.
Okay, Professor Spector, either you've got the motion detector going, or you've really asked to speak now.
I really asked to speak now, and I asked to speak about what effect, if any, this would have on existing businesses that are offering services to entities that may not be low income. And I'm speaking specifically about eviction assistance companies. There, without naming names, there is a company operating in Texas that provides non-attorney representation to landlords, does not provide it to tenants. And I don't know if they're licensed. I mean, they're providing some services under the justice court rules. How would those fit into your proposal?
You're giving me something interesting to think about that I haven't thought about. My
good.
initial, no, that's why we're here. I really appreciate it. My initial reaction is, and we've encountered this with the tax group as well, is, and it's probably also true of immigration. You do have sort of legal adjacent services provided by non-lawyers in certain areas. And you mentioned eviction services. I think I've learned from being a interested bystander for Kennan's subcommittee that we do have sort of special rules that apply in the landlord-tenant context, and rules that already permit non-lawyers to appear as representatives. And so for you to tell me there's firms that have popped up to provide those kinds of services that are already authorized, I guess I'm not surprised to learn that. And if your question is, does this somehow give them an opportunity to expand their service, or honestly, it's not something that has occurred to me. I would say if you have a specific concern, that is exactly the input that we need, because we can build into our proposal that, if anybody comes along and proposes to offer services in landlord tenant, these are things that, merit special scrutiny or concern. That's exactly the kind of feedback I'm trying to get from tax and immigration and family law. But tax, I think, is a great example of it, because there are CPAs and certified tax preparers, and so, in a way, tax ultimately might not really be that impacted, because the non-lawyers who provide services in that field haven't needed, 5.04 has not been a barrier to them providing services, at least in part because sometimes they're not even considered legal services, even though they, there's some overlap between what tax lawyers do and what some of these other tax service providers do.
Well, I think my concern is that businesses like this exist. They exist to provide services to people who are not low income because they're charging fees. And, could they provide it to low income Texans? Yes, but they say they don't want to,
Right.
And so I wonder, I mean, I will be happy to send you a link to a website of one such firm that you might consider in your subgroup. I don't know what the answer is, but I appreciate your willingness to look into it.
Yeah, and this idea has come up with the tax lawyers as well, that there are some people who have kind of gray area type practices, people who offer, I'm going to speak now to the tax area, schemes to eliminate tax debt or generate tax assets, often firms or providers who prove to be somewhat unscrupulous.
Yes.
And they're able to operate outside of kind of the ethical restrictions on unauthorized practices of law now. But if there were somehow a way to draw that type of practice under the regulatory scrutiny of something like what we're describing, that it would be of benefit. And I think it's an interesting idea. Maybe it's a next step beyond getting this kicked off. But yeah, no, I would love to look at whatever you can send me.
Thanks.
Both from my budgeted time in today's meeting and also my other commitment that's kept me from Austin, I've got about 5 more minutes. And I'm not there in the room. Kenan and Lisa, is there anybody who's wanting to say something or?
No? At least they're not expressing a desire to say something. Does anybody?
Okay, well, I know your prior conversation was very fruitful and went on, and I guess I'm inclined, if we've sort of come to a natural stopping point, to give you 5 or so minutes back. But I defer to my co-chairs in the room to sort of guide us from this point.
Yeah, I think we'll probably just like a brief 5-10 minute break to go to the restroom, refill your iced tea cups or water cups. And so we'll get started back at 1:30 instead of 1:30. Oh, y'all don't, those times are for us, aren't they?
Yeah.
So we'll get started at 1:30.
Let me just say again, thank you for all of the questions and input, and I genuinely would like, if something occurs to you tomorrow or in a week, even if you send me a fragment in an email, I'll be grateful for it. And again, I'm sorry I wasn't with you in person, but I thank all of you for all of your work on the project.
Thank you. Good luck with your other meeting.
Thanks a lot. Okay.
Okay, we'll be back at 1:30. Okay, well, welcome back, everyone. And we are going to shift to the recommendation from the licensing subcommittee. This is page 119 of the meeting material PDF, if you want to follow along. And I do have, as a little bit of a disclaimer, my subcommittee was unable to meet until yesterday afternoon. So I circulated to the full working group the document that we were discussing yesterday afternoon in our subcommittee meeting. So I will orally update you on some ideas that we had and recommended changes to this document. And I apologize for that, but that's why it's marked draft and I'm putting all these disclaimers all over it, is because I didn't want to say anything and not accurately reflect my subcommittee's hard work on this case. But so just as an overview, we are prepared to make recommendations on qualifications, although the language is going to be tweaked a little bit, but the concept is there. So who could seek a paraprofessional license in Texas? What kind of background would they need to have? And what other kind of entry requirements might there be, like an exam, character and fitness, that kind of thing. I also believe we're fairly ready to get extensive feedback on disciplinary rules for licensed paraprofessionals. And and so I'm gonna kind of start there, and then we'll see where we get in this discussion of what other, for instance, we can probably knock out some continuing legal education discussion too, so, but those are kind of the big ones that we wanted to talk about. So moving first to qualifications, this starts on, page 120. And just as a general matter, the criteria that we are recommending for qualifications really in large part tracks the eligibility requirements for the paralegal division of the state of Texas, which is a pretty extensive group of paralegals, professional organization of paralegals, already housed at the State Bar of Texas, and they had a already tested means of criteria that is both education-based and experience-based. So I believe we've talked about this at our last working group meeting, but we all know, we've all had experience with a 20-year paralegal who may not have her degree, undergraduate degree, but she has 20 years of experience. And how we, so we want both your ability to enter the system to be both education-based or experience-based or some combination of the two. And so that's essentially what this criteria is laying out. And then for each paralegal and tracking off of the scope of practice group, the paralegal license would be for a specific area of the law. So there would be a paraprofessional license in family law, a paraprofessional license in landlord-tenant law, a paraprofessional license in housing and in probate. And so in addition to the general criteria, there are certain subject matter specific qualifications, including what percentage of your practice incorporates that, like how much of your time are you spending on family law cases? Just so you know, just to stop right there, I'll give you an example of what little tweaks I might be making. When you get there where it's 50% of the candidates' practice must be in the subject matter, we've decided yesterday that means within 3 of the last 5 years. We need some kind of those are the kind of things I'm gonna tweak as we go along that's not on this paper, but that so that's one I noticed, and I'm gonna go back through my draft minutes to hit all of them related to qualifications here in just a second. But that is the other one that we discussed looking at this is we do not want to limit a qualified paraprofessional to a single area of the law if they are qualified in multiple areas of the law. So think of the rural lawyer or the rural paraprofessional who, like a lot of our rural lawyers, practice, dip their hands in a little bit of everything. And those individuals are certainly capable of providing services to low-income Texas as the scope of practice committee has outlined, and they're serving communities that we know there's need in. These are communities that we may not have lawyers in too. And so what we decided yesterday was that your first license, you would need to show 50% of the practice area in that specialty, but subsequent license, you would not, that would be some lesser number, right? Because if it's 50%, that means you can only get 2 licenses, right? Just by the nature of it. And so that those percentages might drop down for your second or third license, assuming that you are otherwise qualified. And then I'm gonna pull up my minutes to make sure I did not leave anything else out on that topic, and then I'll open it up for questions. My idea is let's talk about part of this, discuss, move on to, and not do a whole thing. Let's see. Yeah, 3 to 5, look back. We also discussed adding something that would allow some sort of waiver for some of the requirements if needed be. For those of you that are board certified, you may know that there's established criteria for each of our certifications. But if you don't quite meet the standard, like just as an appellate lawyer, I can tell you one of the big ones is you may not have enough oral arguments to meet the criteria. You can get a specific waiver from the board. So we'll probably try to draft something to kind of get that out there, you know, and it might be like percentage of practice, like again, a rural applicant who, you know, she's 40% of her time is family law, but she can't get the 50% of the time, or she wouldn't, like she's doing all these things, right? So we decided that we would do some kind of exceptional circumstance waiver, giving whoever the regulatory entity is the ability to waive some of the basic requirements or specific subject matter area requirements. And I think with that, I'm going to open it up for questions on qualifications.
I have one question. In regard to qualification A4, it strikes me that you could get somebody who states something entirely different from the law, and maybe has been a paralegal in that capacity for a year, but not really exercising some of these more sophisticated tasks, and maybe that's covered sufficiently with the subject matter specific qualifications.
I think it will be, because you're gonna have to have a look back of 3 of the last 5 years that you've actually been doing it, but you're actually pointing out that probably Grace and I need to go back and make sure there aren't tweaks that need to be made to the general qualifications in light of the decisions that we've been making on the specific, because there's some tension.
Right, there's a little tension,
Yeah.
and if you say to that end, and you probably already thought of this, but for the subject matter specific qualifications, if it's a 5-year window, and then you look at the qualifications, and most of them are 1 year.
Yes.
And so some of them are different, but none of them are 5. So that might be something.
Yeah, I mean, that's what happens when you have a subcommittee meeting yesterday and make
Yeah,
decisions.
yeah.
But your point is very well taken, that we need to look closely at that before we submit the report for final vote at the next working group meeting. We'll clean that up.
And the other related question is qualification A10 refers to having a JD from an ABA approved law school. And then subject matter specific qualification A1 is the JD from an ABA approved Texas law school. And I just wondered whether that was intentional or if they're meant to both be Texas.
I think we're gonna strike Texas. So these are what we call near passers. So if you sit for the bar exam and you don't quite pass the bar exam and you wanted to be a paralegal or a paraprofessional as a means to earn income, maybe until you take the bar exam again, or maybe just as a matter of a new career choice, right? I decided I want to be a paralegal or paraprofessional instead of a lawyer, and my JD helps me. Nadia, who's the head of the Board of Law Examiners, is on our committee, and she strongly supports allowing near passers to be licensed paraprofessionals. So I think it's the Texas that we need to strike.
Well, don't you think you need to keep in Texas though for the subject matter specific, because that's sort of the
Oh,
point.
because, yeah.
Yeah, I mean, if you don't go to a Texas law school, you don't know anything
Texas
about
and
Texas
Texas
law.
yes.
And it is unique. And then the question is, would you keep 10 in the prior list?
Well, I think if you have 10, then what you need, that was my question, because I was concerned about having 10, but then there's nothing 1, 2, 3. I mean, probably that applies to that, and so you're relying on 4 for someone with a JD from an ABA approved law school to be qualified in a subject matter, and I'm concerned about the lack of what is the approved training going to be, and how much approved training, if they only have, if I get a JD from California and I come here and I say, I wanna be a paraprofessional and represent Texans in housing court or probate. And let me tell, oh, that's a good example. Probate in Texas is incredibly different from probate in California. So I better have some really good training about probate in Texas.
So first of all, y'all aren't letting them do very much in probate, just for the record.
Oh, I
But the less snarky, actual, and it's a good thing to think about as we're thinking about this, is what we're trying to create with a regulatory structure is, has to be evaluated in light of what the scope of the license will be. So we don't want to over-regulate as has been done in other states, and we make the entry fee into this, and by entry fee, I mean whole shebang, not like, here's my $20 for my license or whatever. But you just wanna make sure that the whole point of this is to have more boots on the ground, right? We don't have enough lawyers to assist low-income Texans right now, so we need more boots on the ground. And so I think the idea is, in general, as we go through these rules, is to keep in mind, given the limited scope of their license, how much regulation do we need in order to make sure that the public is protected for what little they can do? And so that was my less snarky way of saying that to seek it in. But as far as 4 goes,
it's like I am just the facilitator of the group, not the decider.
But specific to your question on number 4, what I think is an approved training might be a community college course in paralegal subject matter specific.
And like ACC.
You can imagine, if you build it, they will come kind of concept that some of these community colleges will start doing programs specifically geared towards licensed paraprofessionals. And we want that, if you had a course that was specific to landlord tenant issues or consumer debt issues, that we would love for those colleges to start that, and then we would honor that in our qualifications criteria.
So the entity in charge of that would determine, okay, that's an approved.
So it could be state bar approved too.
Yeah, or
somebody's gonna approve it.
Yeah.
It could be Supreme Court approved. But so we don't know exactly, there will be an approved list.
Well, I just think
beyond what we can probably resolve among the working group.
You could show up at the advanced family law for the week and start from boot camp to end, and if you were already a JD from an ABA, and I would think, okay, you're good, you have enough.
Or like some of the 101 courses.
The 101.
So we have like an appellate 101 that is
like family law 101.
Yeah. And so, yes, somebody would approve, and who might approve depends on where this is housed, right? And so I think my subcommittee is leaning towards this being housed at the JBCC. You're waiting for me to activate my setup. No. But it also could be housed somewhere else. And so that entity would be the one who would decide these courses would be the approved courses, is the way I envision that.
And this is a nit, but I wonder whether A4 on subject matter specific qualification should say have completed approved training as opposed to participated in.
Oh, that's a good point. Yes.
Successfully.
Yes, right.
Gotten an A.
That's good.
I still have a problem with conceptually what we're talking about.
Okay.
Are we talking about a trained paraprofessional that gets licensed, but they can't charge, right, for their services? So why would they do it?
So I think
unless they're affiliated with a law firm or someone else that will pay their salary?
I think they would be most likely affiliated with a legal aid provider or a nonprofit.
But I think, Richard, the only exception where they can't charge is that justice court provision. We were just.
Yeah.
Oh, just with
Yeah.
that one. Okay.
Yeah,
So the
that's-
other one, so they
Yeah.
could charge.
I was gonna say, I don't think that's.
So they could
a-
hang a shingle and say,
I'm
I'm gonna do 50.
I'm not sure.
Therein lies the question, right?
That's confusing me, I'm totally confused, and so.
Well, I mean, I don't see it, I don't necessarily see it happening like that you would be out in private practice. What I could imagine is that a group of paraprofessionals, licensed paraprofessionals, decide they're going to start a nonprofit to serve other nonprofits who cannot afford to have any kind of legal staff, whether lawyer or paraprofessional within their organization. But this group of paraprofessionals would say, you know, our nonprofit is here to team up with you and to provide these services that are allowed under our licensing thing. And so that that nonprofit might be grant funded, so that they don't charge their clients a fee for it, or otherwise private donations funding them, something like that. So that's another kind of way I could see how this might help get more boots on the ground and more low-income Texans served through what we're doing here.
Well, and then back to the TOJI model that already exists. I can't remember how many lawyers are in our state already providing services with that model. But they have a requirement to do a certain number of hours of pro bono. And so it's possible they could have, you know, people come in and assist with the pro bono. So there are ways within our existing system to incorporate the type of licensed paraprofessionals we're thinking about. But to the question of, are they precluded from charging, to Karen's point, the only rule I'm aware of that precludes receipt of compensation is that 500.4C of the Texas Rules of Civil Procedure. But I think a bigger kind of philosophical question is, okay, but can they afford to pay anything, even if they're not in a system where the person providing the service is precluded from charging something? And ultimately, I think that gets back to a degree to how we define low income, right? Like if you have a person who's at 125% of the federal poverty guidelines, doubtful, right? To your good point that made it into the memo, that person probably cannot afford to pay a penny in legal services without not paying that penny toward rent or electricity, whatever it may be. But if you had somebody who was at 400% of the federal poverty guidelines, maybe they could pay a little, it wouldn't be much, right? And probably wouldn't be much at all, but they could pay something. And this gets into the sliding scale fee structure that attorneys have been using in our state for, to my knowledge, quite some time. So I don't know if that answers the question.
Yes, I'm texting one of my colleagues, because I know in special ed, parents hire lay advocates to give them, to go to meetings, that even under Texas rules, they can represent someone in an administrative hearing. And so I don't know whether or not, I know that they pay to go to ARP meetings or IEP meetings, but if they go to a hearing, whether or not they can build their point. I mean, the reality is if you win, then the school district has to pay your fee.
Oh, okay.
Because you.
And then you can end up in federal court. Which they can't do.
Right.
Yeah.
Right.
Yeah.
Because the structure isn't in and of itself limited to say, and if you're a licensed paraprofessional, you can't charge for your services.
That is not a proposal on the table.
That's a huge issue.
That's a question, isn't it?
Right. Right now, the parameters are, it has to be for low income Texans, right? That is as set by the Supreme Court in the referral letter to us.
But how are you going to regulate?
Yes, so in the interest of not hijacking, because it is a very important and big topic that is not specific to my portion of this.
Okay.
And so
it's not part of the licensing.
well, I mean, to the extent that the three of us co-leaders are going to have to sit down and incorporate all these into some kind of formal rule structure, then, you know, but I didn't see that piece being part of the licensing part of it, but I could be wrong on that. I mean, we haven't sat down and talked about where that's going from the rule. I was thinking it would be, so in order to serve low income Texans in these subject matters or whatever, you can do this, but
But it
we
it
don't
has to
know.
be regulated.
Yeah,
Yeah.
But it's like what
I
happened
think
in
it does have to
Washington.
be in there.
They had that training program, licensure program
Somewhere.
for paraprofessionals, and then no one would, and so it disbanded. And so there has to be a financial incentive. I mean, I could see if you had a paraprofessional that's licensed and works in a law firm, then the law firm can bill for their services, but can they go out and hang their own shingle as whatever paraprofessional doing family law? Could they charge their client? Otherwise, they can't charge, and there's no reason. And I mean, living with an agency that, and Karen could attest to this, we're always trying to get grants. And if you're lucky to get a grant, you may get it for 1 or 2 years, and then it dies. And so it's really hard to sustain it.
Right.
And so I don't know how you're gonna have a model that would grow over time. Unless you're affiliated with it. If we decide as a legal aid program, you know, we want to use paraprofessionals, we're gonna hire less lawyers, so we can do more outreach. I mean, if we get budget cuts, we may have to do that.
Well, and also just, you know, I'm thinking about, the women's shelters, who, you know, they may not be able to afford a lawyer on staff, but they might be able to, they could afford a paraprofessional who can do this limited scope thing, so, I mean.
Right, that's
Yeah.
a possibility.
And I could send those people to training in the community colleges and,
Yes.
you know, it's not prohibitively expensive.
So any more comments about the criteria? It sounds like the consensus I'm hearing is in general, you like the structure of it being some general criteria and then some subject matter specific criteria. There's some tweaks to be had in this language, just for drafting, wordsmithing, but that in general, are there any comments about just in general that we're landing on a good combination of education and experience?
I think that's good. I think in light of our conversation today about the justice court and not being subject matter related.
And that's it's a good point. We obviously didn't have that information,
No,
so.
Just might think about you might need a separate, instead of, well, I don't know, maybe instead of consumer debt and eviction, you have justice court licensure. But then, I'm not sure what your subject matter qualifications are. I'm just posing more questions for you than answers, but.
Yes, and that also will go into.
But I think if someone is like a paralegal who's done, what you might do is change the percentages for the justice court paraprofessionals. And just say that they've done some consumer or housing or a combination of both, because that's really the majority of it.
Yeah. Well, and let's just, I appreciate the comment, because it's, we'll have to bring that back to the subcommittee, I think, to discuss further.
I'm getting a little hung up on A4, but maybe unnecessarily so, just in not having any kind of official formal education in the legal realm. So that might just be me, and it's been there for a while, but
Wait, subject matter specific
no
qualification?
general qualification
Other than legal studies.
Cause just because what a paralegal does can range dramatically. Some paralegals are essentially filing. Other paralegals are, and when I say filing, I don't mean filing court documents, I mean filing
Like filing in
papers.
paper files.
Yeah, and other paralegals are out there interviewing clients, filing documents, but it can, I mean, it is, even at my firm, what a paralegal can do, can range dramatically from one day to the next, one day being kind of administrative and the next being more technical, so I just worry about whether that's getting the foundation, sometimes I think it will, and sometimes I think it won't.
Okay, but so they will, so imagine that you are a humanities major or an English major, and then you go decide to be a paralegal, and you've been working for 20 years. Do you really care what they're?
No, but that's not what it says.
Well, I know, but then you're gonna pick up in here in the subject matter specific that they've had to be doing family law 50% of the time for the last 3 or 5 years.
Yeah, I think you pick it up
See,
in
so
the,
just kind of letting
pick it up in the
them-
subject.
The combination would.
There are,
Yeah.
so there's like
Yeah.
the base requirements.
Or
you
pay
just have to do the
for
training.
program.
So I could be like an engineering major. And then I work at a firm, I'm just
So
hypothetically.
you don't like the training, you don't like that part.
I just don't know if it's, I'm just questioning, it's just questioning, it's a hypothetical, you've got an engineering major, it's totally different, number cruncher. They go work at a firm, they're in a filing room for a year, and then they go to a semester in paralegal training, and now that's enough. And that's a possible path. And I pointed out just for what it's worth.
Okay, so what we need to do is add.
Define paralegal when you've worked when you say been employed as a paralegal, maybe you need a definition of what that employment has to entail. Like, not just file the papers in the paper file, but like.
More
substantive interaction with the courts.
Okay.
I don't know.
It's hard, it's just that
hard to.
what paralegals do in Texas, it is such
So
a
broad.
broad range from purely administrative.
Well, there's a
to
difference
substantive.
between an administrative assistant who does filing and a real paralegal.
But not necessarily.
Yeah.
They can be called a
They can be
paralegal.
called a paralegal.
Lisa,
My receptionist is a
I was
paralegal.
hoping you were still on, Ellen.
up here, I'm absolutely here. What might be helpful is to look at, and I'll try to put a link in the chat. The State Bar of Texas adopted a definition of a paralegal quite some number of years ago. And so we have that information that might at least be a good starting point. So let me try to pull that up and put that in the chat, because I think that will address some of the issues, at least that everyone's discussing right now. So.
That's great, and I mean no disrespect.
Absolutely not, none taken, none taken. And you're right, and there's also one reason we have the experience requirement is because there is a difference between paralegals who are experienced and what we fondly call poof paralegals, as in an attorney says poof, you're a paralegal, but you absolutely have no qualifications to be one. So let me put that in the chat right now, that hopefully will
I've never heard it called this.
yeah.
But that's how it happens, like.
It is sometimes, and you're right, those are not the people that any of us would want serving as licensed paraprofessionals at all.
She's resolved.
Okay, this is good feedback. Is there any other feedback on the qualifications? Cause we're, although I will say, this is the hardest part. And this is the part that if we feel comfortable that these are experienced individuals, then I think it makes a lot of the rest of it fall easy.
Yeah.
So I do not want to cut off criteria conversation by any means. I do think it's one of the most important things that we're recommending as a subcommittee to the working group.
And so to share out loud, because those of us in the room don't have the link. A paralegal is a person qualified through various combinations of education, training, or work experience, who's employed or engaged by a lawyer, law office, governmental agency, or other entity. I'm gonna go of specifically delegated substantive legal work, which work for the most part requires a sufficient knowledge of legal principles and procedures that, absent such a person, an attorney would be required to perform the tasks. So,
Great.
That's perfect.
there you go. This is not the mailroom clerk.
Yes.
Right, right. And I said the other advantage is this was already previously blessed by the state bar. So we don't have to worry that we're dealing with something that is brand new.
No, that's great. Thank you very, very much. It's perfect.
Any others, we will be working on including that definition into the rule. Any other comments on criteria? Okay, moving on then to the exam, as we reported to the working group last meeting, we thought a lot about whether we would have some kind of general competency exam, much like lawyers take a general competency exam before they get licensed. We struggled with whether those types of exams do test competency. And we recognize that there are many states across the country that have decided that they do not test core competency. We invited to our subcommittee meeting before last some leaders in Oregon who have what they call a portfolio method. And they're doing it for lawyers and for their version of paraprofessional. I don't know what they're called in Oregon exactly, but and so I thought the portfolio was in lieu of an exam, but it turns out in Oregon it is in addition to the exam. So that was kind of, you know, different. Seems like, again, if you think about, we don't want to over-regulate, right?
Let's do more.
So a long story short is we have set on creating an exam in Texas for paraprofessionals that will be of limited time period. This draft says 1. There are some members who think it might need to be 2 or 3 hours long, but not a 3-day bar exam, okay? So not what lawyers have, but some exam, and focus specifically on paraprofessional, like what is their scope of license, what things do they need to put in their engagement letter, so sort of the code of ethics, when would you need to refer? So it may not necessarily be an exam that tests, let me say that a different way. In addition to any competency for the subject matter that you would need to know about how evictions work or how probate works or anything like that, that a significant component of it would be you understand what the scope of your license is. You understand what you need to tell your clients about that. You understand, you know.
Like an MPRE too.
It's an MPRE general competency kind of smashed together and hopefully not very long.
The realtor license, the realtor exam.
Yeah.
The exam you have to take to be a realtor, it just reminded me of that, would be sort of similar because I know that there's some combination of ethics, of what you can do, what kind of advice, what kind of information you can provide, and substantive, and it can't be that long.
I was about to ask you if you knew how long it was.
I will find out.
Okay, but anyway, so that's a recommendation, is some kind of exam like, so to speak, that focuses on, this is where you're gonna get in trouble, this is when you need to, you know, it focuses on the limited nature of what those individuals can do.
Might you fill that out separately so that somebody that wants to get the ability to practice in different practice areas not have to do that part of
Again, that's a good point. We have not added that in. What we have done is if you have passed your board certification exam in these subject matter areas, you wouldn't have to resit for this exam. And if you, let's see, I'm trying to think if we ended up recommending, I thought we intended, it's not in this draft, and Ellen may be able to correct me if I'm wrong, but I thought we intended if they had also passed an exam to get a national certification that we've defined not just any national certification, but there's some trusted certifications. And that if you had that, it would be the equivalent of the Texas Board of Legal Specialization exam. The idea is if you're testing, we're not gonna make you retest for general competency. Is that your understanding, Ellen, of where we get with, even though it's not really in this draft?
Yes, and I would, just to confuse things, let me throw something else out, because we all need one more thing to consider at this point, is, one of the national exams also offers subject-specific exams. Now, obviously, they're not tailored to specific states' law, but they have family law. I know for sure, and I think they have a state planning and probate. But because those are not state-specific, we might not want to use those instead of something specific to an area of law in Texas, but just throwing that out.
That's true. And then we also, I don't think we really contemplated if we wanted to do, let's say the 1 hour exam is a smash up of general competency in a specific subject matter and ethics, whether we want to break that out so that you would still also have to take sort of the ethics piece of the exam if you got a waiver for the competency part of the exam.
Mm-hmm.
So why don't, with the caveats that I just threw out there, is there any further discussion of the exam? Do y'all think we're on the right track? Taking this comments we've had today and giving you specific language to vote on in November, y'all are okay with the general concept of the exam as we're proposing it?
Yes, but I do, like some other people in your group, question whether 1 hour is gonna be enough to test substantive areas of the law and ethics. Like, it just strikes me that that's not a lot of time. And even 2 hours, like you could, hour of ethics, hour of substance, something like that, it's not.
I think that was Leo's point, who's the head of the Board of Legal's certificate. He does not think an hour exam would be enough. So we didn't vote on that. I'm reporting just sort of our conversation, not a vote that we settled on 1 hour. We definitely are settled on it not being too extensive such that people will want to take it.
I think this 260 score, I think that's so smart. I mean, there's so many people who get very close to passing and it's sufficient in other jurisdictions, but not here.
Yeah.
They have all that legal training. I think that's a really
That's
good
from Nadia. We're very
option.
happy to have your compassion for the near passers.
Yeah.
I just would like to comment again on and I'm not saying a proponent, like, we should absolutely have 1 hour exam, but if we're having all these other requirements that people have to meet, including experience in that specific area, and at least initially 50% of their time spent in those areas, and going to require maybe some sort of recommendations or anything else, I would argue that maybe we don't need a 3 hour exam when we're kind of hopefully checking for their competency in other ways. Just a thought.
Allow them to waive the exam if they have and you may have said this, Liz, I'm sorry, the Board of Legal Specialization, like,
Yeah, they don't have to take the exam.
Yeah.
But the
Sorry.
ethics part.
But the ethics
Yeah.
part, they should.
They should know where their line starts and stuff.
That's why I think,
Yes,
we did
okay.
not discuss that as a group, but I do think we're gonna need to break that down so that waivers are for the general competency, not for the MCLE or.
That makes sense.
MPE.
Where's the
What is it?
MPRE?
Yeah.
MPRE?
But please don't draft it like the MPRE is.
Yeah.
No.
A and B, but not C and D, A or D, but not E.
I always tell people, I always tell students that it's like, first ask yourself, what would Jesus do? And then that's not the answer. That's wrong. Because we're not asking you to do what's right necessarily.
This is the floor. Yeah.
Okay, so now I've lost my place here because I was looking at what time.
Character and fitness.
Character and fitness.
122.
So we are going to be recommending a character and fitness, much like lawyers have, but it's it's whittled down. And so we work with the Board of Law Examiners to be like, okay, what really do you need to know? And where does this application sort of go off course and become the nightmare that we hear about when people have to do their character and fitness exam for being a lawyer? And so Nadia came up with this list that, and I didn't attach the application in Appendix A like I should have, that's referenced there. But it just gives like some school related discipline, of course, a criminal background check, and if you've ever lost a license, if you've ever been accused of unauthorized practice of law, maybe some service information about employment history, you know, child support, arrearages and things like that. But the idea is, again, it's meant to not be a source of overregulation, but enough information that we feel comfortable that any bad actors are being weeded out of the application process.
For the final bullet point, I wonder if you want to restrict that, and maybe it's obvious, but to Texas, because of course you have the notarios who are trained in Mexico, I think it is, right? So in one place, those are real qualified individuals. Here in Texas, it's been problematic and people have used that term.
Yeah, or outside of Mexico.
Right.
Something like that. Okay, that's good.
And I think I know there's a statute that addresses notarios. I can't remember what it is, but maybe it has some language.
And this is a rough, if I had attached Appendix A, I bet that's on there.
Oh, okay.
The exact wording might be a little bit different than the summary information, but that's a point well taken, and we'll make sure in our final report to you that it takes into consideration that comment. Any others?
I don't love the financial information requirement. I don't. Just because.
So it's gonna pick up your bankruptcies, your failure to pay child support, your.
Maybe, but it also says past due debts. Like, what does that mean? Like if I'm behind on my credit card? Are you really just thinking if they filed bankruptcy? But
I wish I had Appendix A because I feel like it's a trend. But that's tracking what kind of financial deterrent, and you included that in your
it's been too long, Kim, I don't spend a while.
Yeah, so that is tracking from the lawyer requirements. Now, we can decide we don't want to, in part because, I mean, we're not, well, I think one of the reasons we care in as lawyers is that we handle client funds, right? In our old accounts and things like that, and so there's a need. If you're going to be handling client funds, then we want to make sure you understand how to handle funds, right? And so maybe there's not a need for it with, but yes.
Actually, isn't it also the concern that you're more likely to want to cut edges and make more money if you are in financial trouble? So you're sort of under a lot of pressure to maybe cut corners or distracted or led down. That also.
I think about a lot of the population that we're serving and the people who serve that population are often financially in distress, I think, maybe. I mean, if you think about the pay of a social worker, it's pretty not fantastic a lot of times. And so I wonder if we're adding a barrier that's not necessary, or because to ask about your financial situation. I mean, I guess here's the other thing about the bankruptcy that I find interesting. Because in the United States, you can file bankruptcy and you get a fresh start, and that's the whole point of it. Not to be penalized for the rest of your life because you can't pay your debts. But that's why I don't have debtor's prison. So I wonder if that's even an important question to ask. Just something to think about, maybe.
I will pull this back because I definitely want to have a better appreciation from the Board of Law Examiners about what they're assessing and why. And so we'll mark this as something to discuss and report back to the working group next time.
I was curious about the school-related discipline. How far back are you going on that?
I think that we'll have to, someone's going to have to draft an actual application, but remember, not everybody has an undergrad. So I don't know that we're gonna go back to high school, but, you
But
know.
maybe if you qualified like within the last 5 years or something, because I can see people who have matured over years, you know, that
Yes.
what they may have done as children.
This has come up before too, at the Board of Law Examiners for law school applicants. Like, I remember there was a story about somebody who had taken a Snickers bar and had to report it, you know, and it was just, it seemed a little extreme.
Yes, or the time I walked out with an exam after.
Who did you?
Oh, I got called into the dean's office, I'm like, just crying, like, oh my God, I'm never gonna get, I forgot we're recording, I should probably not do this, but, I mean, I was mortified, and it just was like, I was so excited to be done, I just wrapped everything up and walked out.
No, but the more serious point is,
Yeah.
what do you wanna hold against people and for how long, right?
Mhm.
And I think that's a really legitimate question, to ask.
Yes, okay, I'll take that feedback back too. Any other comments on character and fitness? Okay, now we're gonna skip over this code of ethics, except for I did make a note of.
Sorry, saying it myself. Military service information, and it's used all of the time, but frequently folks that have been traumatized by have disciplinary charges as part of their military service. So it's something it's a practice area that we help quite a bit with in legal services, where we're doing discharge upgrades because of PTSD. So, but not a lot of people get those services to get those taken off and you know, have their discharges upgraded. So it just makes something else to consider when you take it back.
That's good, I appreciate the comment, and then I also should say too, that, you know, a lot of this is self-reporting. It doesn't mean that you're not going to be licensed because of something that you report. You're more likely to not get your license if we find out that you did not report, right? And so, you know, from what I understand of BLE, like the vast majority of these character fitnesses just like shuffle in and out, right? And then that leaves them looking at the smaller percentage, get staff reviewed, and maybe they don't even call anybody in to even discuss anything, but it just got flagged for whatever reason to do a staff review of it. So then you've got a whole other ones that roll off the conveyor belt with staff review, leaving them with a small amount, like, hey, maybe we need to call this person and then talk to them about it. But in no event does the reporting of it mean that
Just
you
knock it
will,
out.
yeah, it does not knock you out. There's a process, so.
That's good.
Okay, so we're now going to page 124 of the PDF that was circulated for today's meeting, the book, working group material book that we sent out. And this is the disciplinary process. And we have modeled this off the Judicial Branch Certification Board, JBCC's disciplinary process, primarily from their guardianships, which is the one that's closest to, the one we think is closest to what we're allowing here. And so you can see that there would be a form where clients could make a complaint against a paraprofessional. We've had some discussion about whether that complaint needs to be sworn or not. Our discussion, we definitely don't want to have to require it to be notarized because that would take a lot of work on people's part to go find a notary, but it could be sworn under penalty of perjury. I don't know that I can report that we have a complete consensus on that. So right now, that's just kind of a placeholder, something we've discussed internally. And then the other thing that we discussed internally is remember in this process that losing your paraprofessional license does not mean that you wouldn't be able to continue to work as a paralegal. So this isn't like our law license where it really is our livelihood, and if we lose our law license. And I say that only because that is one way that we justify this being sort of a lighter version of what we experience within the lawyer discipline world, especially in terms of due process. I don't think there's anything in here that somebody could say would be a violation of due process. We obviously did not intentionally, I mean, there is an appeal process and there is, you know, but, you know, we think this is a fair program, but I also just wanted to state for the record that this is not a license that you wouldn't still be able to be a paralegal. You know what I'm saying?
Yeah.
It's not.
Yeah, losing a license doesn't mean you lose the ability to work as a paralegal.
In your choice of world, yeah, exactly. So, anyway, I don't know, without going through it, but there is like notice requirements, there's a hearing requirement, there's an appeal process. I think what might be, they can penalize you financially, or they can, you know, revoke your license or put other limitations on your license. You get to appeal it, I've said that already. In lieu of a hearing, there could be a general disposition, agreed disposition. We did go ahead and include the ADR provisions of this. I've been told that they, the current JBCC does not see many alternative dispute matters coming to them currently with all the people they license. And then this also, within here, and I'm sorry, I can't point to exactly where it is, I was kept scrolling more, but there's there's a way to have something administratively dismissed. So if someone files a complaint against a paraprofessional and it's not the kind of complaint, it allows the executive director of OCA to administratively discipline it. You could always appeal that if you wanted to, but there is a means to look at a complaint, and on its face, it's not actually alleging, you know, a violation of.
Like when the opposing party complains about, well, you didn't tell me that,
Exactly.
I had to tell you that.
Exactly.
Right, so it's kind of akin to what happens in the attorney grievance system now, where you get a complaint and you're like, that's not on its face alleging what is professional misconduct.
Exactly.
And so
there's an administrative way to get it dismissed without going through the whole stuff.
Yeah.
And that exists for JBCC now. So all of those licenses under JBCC have that administrative dismissal process. It's actually not in the rules, it's like it's a separate thing, but we just moved it internally. We're just put it in there. I think the most effective way, of course, I want to accept any comments if you already noticed something that you want to ask me questions about. Our two working group members who know the most about disciplinary process in general, Sid Harrell, who is the JBCC chair, and Linda Acevedo, who was a longtime counsel here at the bar in the grievance world. Neither of them are with us today, so I may not be able to answer your questions. All that was to say, I can get answers, but I may not be able to answer it. And then I accept if you do want to sit down and really think about it and send me redline comments too, if there are tweaks to the way it's drafted as opposed to the concept of.
One of the things that I would suggest, just sort of generally, is the way that notice is provided to the licensed paraprofessional, and we've seen this, and that's been discussed at our state bar grievance process, because maybe in multiple ways, and certified mail is sort of, I don't know. I don't say anything certified mail anymore. I just noticed in the estates code, because I didn't know what it meant, we've added a definition, and it's called a authorized, no, that's not right, delivery method. And it's defined at the beginning of the estates code. And it says it's like sent by certified mail or a method authorized by the Internal Revenue Code, which actually is like FedEx, UPS. Because I went down that rabbit trail, but it might be worthwhile to be sure that we end electronic mail. Because I think an email and a written are important. Just from the standpoint of when we deal with people who have complaints, that we be sure that they are noticed in case there's something else going on with their world.
Judge Harrell reported to our subcommittee that the JPCC currently uses 3 methods of communication: email, certified mail, and regular first-class mail. They use all 3 forms of contact, especially when summoning parties for hearings.
Yeah, that's good. Yeah. And as to the, I know you haven't made the decision, but as to the sworn or unsworn, you might think about treading carefully.
That's
new in
the attorney grievance system.
Yes.
Yes. You know. Yeah.
Okay, any other comments? Anything from our online participants? Okay.
I have one quick question, which is a little off topic, and I apologize if it's been discussed before. But is there going to be any attention to preventing somebody from using paraprofessional licensing and advertisements, or is that something that we're not really concerned about?
I think that would be addressed in the code of ethics if we're going, like an advertising rule. Is that what you mean, Craig?
Yeah, something like that, because you don't want somebody trying to say that this is some super distinction that is better than being a paralegal or something else, I think, in order to make money off of it, since that's not what our intention is, for somebody to turn this into a huge profit center.
That's an excellent point to be added to our code of ethics, which we have not discussed as a subcommittee yet, except for to let you know there will be a code of ethics. We just and to let you know there's already a code of ethics for paralegals. And so we've modeled, the current draft is modeled after the paralegal code of conduct. They have a code, and then they have like a whole handbook that our very own Ellen does for, she's the editor of, and I now have a copy of. Ellen, I should bring it to you sometime to get you to sign it for me. So anyway, but that's a good point, Craig, because I don't think it really discusses that, because most paralegals are internal, right? They're not external. Ellen, my recollection is there wasn't anything in the code of ethics related to how you represent yourself outwardly.
Oh, no, there is, which is that you must make sure that people understand you're a paralegal, that you're not an attorney, that you can't give legal advice. If you think anyone is assuming you're an attorney, you must interrupt them and correct them immediately. That's actually a huge deal for paralegals. And I would think we would want something similar, that where someone who is a licensed paraprofessional made it clear, while I'm a licensed paraprofessional, I have limits to what I can do, and I'm not an attorney, and those kinds of things. But
I think of course that kind of stuff is in there. I think I read into Craig's comment a little bit differently, but sort of like, I can't represent that I specialize in such and such unless I'm actually a board certified, specialist,
Right. And we don't, ours doesn't address that, but we have to follow the attorney rules as well, so we understood that you could not say anything about, I can't put down I'm an intellectual property specialist because I'm not board certified as that. So.
Yeah. Okay, but that's point is well taken, Craig, and we'll keep that in mind.
Thanks.
Okay, so continuing education will be a requirement. We're hoping that this will be low cost or free, because again, we're trying to keep our overall licensing costs low as possible. But we settled on 10 hours of legal education each year. And with 3 of those being devoted to ethics. We have gone round, and these are the numbers that we've landed on. There's room for disagreement about what those numbers should be. Is 10, I would not want to go higher than 10. Our discussion has mainly been, is there something less than 10 hours, which is more than a day, right? And you have a limited scope license, and do we want to really require more than a day of CLE every year for paraprofessionals, given what their limited scope?
One thought is that it depends to a degree on what constitutes the CLE, right? So for attorneys, it can be self-study.
We've eliminated self-study. And if it's in here, that's a typo, that I did not take it out.
No, I was just looking.
It
at
was
the
originally
language.
drafted, and I think maybe the last working group meeting, it included some self-study hours, but we've decided we did not want to do self-study hours. Although there's some discussion about if you lead a paraprofessional CLE,
Right.
teaching it may be different than I sat and read a book. So,
Yeah.
but right now we've just taken out self-study altogether because that was hard to draft mainly, but it's noted as part of our discussion.
I do think the teaching component is worth considering. I mean, that is different. Every time I teach, I'm digging in.
Yeah.
And doing a different kind of self-study, if you will, than if I'm just reading it and retaining what I need to for my own.
Yeah. So we could, I guess you could draft it up to 3 of those hours. Instead of using, I would avoid the use self-study, but in preparation for presenting at a approved paraprofessional course.
And I think there's existing language you could just
I think we have that in our
borrow.
CLE.
Yeah.
I think we
Yeah.
reported separately.
We do, I
Self-study.
just reported
Yeah.
separately for
She's like,
teaching.
it's-
Okay.
Yeah.
Okay. Ellen, you look like you were about to say something, but maybe.
I was gonna talk about the number of hours, and I'm not married to 10 hours, but I will say that for, I have 2 certifications through national paralegal organizations, and I am required to have one of them, it's every 2 years recertified, one is every 5 years, but it works out to 10 hours per year of CLE. So I will say that anyone who is certified, that's not going to seem like an unreasonable number.
Right, and I'm glad that you get to make a lot of profit off of your taking those 10 hours every year. You know what I'm saying? Like, in other words, it's not.
It's reasonable.
Yeah, I mean,
Right.
it's reasonable. I'm not saying it's unreasonable. I just want us to be thinking.
Exactly, and I'm not saying that we should absolutely do 10 hours, I was just saying that if there is a precedent for that certified paralegals are already used to having to meet. I do think it's important to say that, like, for board certified folks, that the CLE of course be in your subject area, not, if you're a family law licensed paraprofessional, you don't need to be taking a CLE on trademarks, that's not gonna help you. So, I know we want to focus on that, but, and I will note that the paralegal division offers online CLE that's reasonably priced, as well as in-person CLE that's reasonably priced. So not free, but reasonably priced.
Well, and I'll note to that point, there have been many times over the course of my legal career when I've been offered free CLE in exchange for committing to do a certain number of pro bono hours. And so it may be that we want to incentivize to a degree through the CLE offering the provision of no charge legal service, right? Pro bono. Yeah, which they're gonna.
Already doing.
They're gonna do some already, right? That's probably the bulk of what will be done, but it possibly won't be all of it, right? Like.
Yeah, I mean, I'm kind of hoping, I could see like maybe a clinic at one of the law schools being like, we're gonna do our 8-hour eviction subject matter, we're teaching our students, hey, licensed paraprofessionals, you need to come get some CLE, you can jump on in or something like that. I mean, I think you're gonna see non-traditional continuing education providers jump in.
The the paralegal division offers a 2.5-day multi-track, multi-subject CLE event every year, and I can see them offering CLE specifically for the licensed paraprofessionals as part of that. I don't know that they will, but I imagine that they would want to do that.
Okay, any other comments on CLE? Dues and reporting requirements. We do anticipate there being dues, significantly less than attorney's dues. Keep in mind with, if this does get placed at the JBCC, as Justice Massengale mentioned, by statute, those programs are supposed to be self-funding. So that's why we didn't put an amount. We're just anticipating some dues that the governing body would adopt. But we would include annual reporting. That would include any grievance that was filed or sanctions that was filed. Obviously, we would probably have the grievance information, but any sanctions filed, any ongoing criminal conduct since the last reporting time. And then importantly, some data about the number of low-income Texans being served by the paraprofessional. So we're going to use our annual renewal process to be the point at which we collect data on the success of this program that we are designing in order to serve more low-income people. So that we have not delineated exactly what the elements of that report would be, but the idea is reporting information that would allow the Texas Supreme Court to assess whether what we're doing is actually helping, like serving the purpose that we're doing this for. Yeah.
So jumping back, and I apologize to do this, but for CLE, the subject matter focus, I think to Kim's prior point, if you have justice court rules that aren't restricted to particular subject areas, might need a different approach. This is where the devil's in the details, right? Like if you go beyond certain types of cases.
But I support it, so we can figure it out.
We can figure it out, yeah, I just.
Because it could be it could be like a multidisciplinary approach to that particular certification.
Yes, but I mean, just to this point, what if you have putting aside the justice court issue, what if you have a paralegal who has multiple licenses?
Right.
I guess you pick 1 year, you're gonna do 10 hours and anyway, that's also not addressed in here, so we obviously have some tweaking to do on this rule related to subject matter specific.
Now we have Judge Holmes again. Do you mind if I ask you a question, Judge Holmes? If you're to craft rules allowing individuals who are not attorneys to represent others in justice court without restricting the subject matter, when you think about training for these people and the subject matter that you would want them to be trained in as a justice of the peace, what comes to mind?
I mean, ideally, you give them a crash course in contract law. All right, but that it's probably too broad, right? I guess what for me, what I find is when people are being represented by non-attorneys, it's understanding the difference between an emotional argument and a legal position. Because sometimes the person is there and they're really just telling me, why this person is nice, and that's not in dispute. The question is, is the contract being met? Is the evidence supporting that? So a primer in Well, actually, I'm working on a project right now to get a foundation grant for us to do a voir dire project because people have no idea how to select a jury, and that would be helpful if they had any concept of that. I give them a packet and they just stare at me and go, "What is this for?" And I go, "Well, this is to help you, weed out jurors with bias." I've been listening along for the past hour, and the paraprofessional part really interested me, especially about 10 hours. Because that is more than a day. But then I had a thought as I was trying, I don't mean if I kind of revisit this morning, I was only here for the first hour, but in my drive to and from a meeting, I was thinking about, allowing non-lawyers representation for extra people in court. I think that is very helpful because a lot of people need assistance with understanding and reading and then remembering things. They're very nervous, and they did not prepare an outline or a trial guide or a trial notebook to remember that they need to hit all the parts of their case. But I guess in all of our discussions, my assumption, or kind of built into it, is that the party being represented will be present with this non-attorney representative. Do we need to make that very clear? Because as a lawyer, right, I just, in my letter of representation, I can show up in certain events for like pre-trial and say my client can't make it, Your Honor. And what I sometimes encounter, especially with evictions and debt cases, is that the person is low income. They are trying to avoid losing more money by taking time off of work, or their job does not allow them to take it off. And a friend of the family will show up and say, "Hey, I'm here for my girlfriend. I'm here for my dad. I'm here for my mom. She can't make it." And then I'm left with this question of, who are you? Do I believe you? Because it's not like the defendant or the plaintiff knew to send me a letter of representation in advance or tell me this person was appearing. And since, as an attorney, you're obligated, there's an oath you've taken already. I can rely, in essence, on you representation to the court. I can't do that with some random third party. And I think about in debt cases with fraud and identity theft, what if the person pretending to represent them is the person who's committing the identity theft?
Right, and this raises the question that we were discussing perhaps after you left, and that's the difference between assisting versus representing, right?
Yeah.
For me, right or wrong, implicit in assisting someone is that person's there and you're assisting them. Whereas with capacity, to your point, you can be there and represent them. And maybe that's, I'm just thinking out loud, but maybe what we do for the licensed paraprofessionals, we have certain areas, but we have in the assistance realm, we still keep that open as it is now, but maybe expanded a little bit. It's just something to think about.
I think if it's not in our code of ethics for paraprofessionals, I think we do want to make them officers of the court. To the extent they appear in court, much like we are officers of the court. And kind of implement those within the disciplinary rules for lawyers, that same concept into
candor with the
court, things like that. That may be in there, Ellen, for all I know, but I'm just making a record of, let's make sure that gets put in there and it's not.
Absolutely, I agree, and I think that's more to your point of representation versus assistance. And if you are representing a client in however limited capacity, you have certain obligations to both your client and the court that traditional paralegals don't have those exact same obligations. So you absolutely should include that.
Would it be in the code of conduct or ethics that you have to provide written notice to the court that you're representing if you're doing something that's authorized in the court? I mean, or, signature on it, whatever, but I'm thinking about the justice courts because there's not usually, there's an answer. But we really, who's signing the answer?
Sometimes.
And that makes me wonder, and maybe Judge Holmes can answer this or someone else, but if assuming this paraprofessional licensure goes forward, if it's not going to also trigger some additional, at least court rules, if not, procedures that are going to have to be updated to address the fact that, someone may be represented, like Judge Holmes, you may want to have some sort of a form that's, completed or something, I don't know, that additional that lets them know, oh, I'm, a licensed paraprofessional representing my client, as opposed to, as you said, the neighbor or the family member or whomever, so.
I think that'd be easy enough to implement. You know, for JPs, even non-lawyer JPs are required to go through 20 hours of education every year, and it's put on by the Training Court Center out of Texas State University. And that would be something that could easily be updated if the rules get changed to say, you know, now that we're going to allow an expansion, people can be assisted if we get the rule changed. Anyone can assist them, but that means that person must be there along with the person assisting them.
Right.
A paraprofessional may be allowed to represent, but in order for us to know that, they're going to have to give us some written documentation in advance, and then present some credentials, just like we
Right.
have with attorneys.
Exactly.
How do you know when a representative for the property owner comes in, the manager, how do you know they have authority to be there on behalf of their client?
I've at least never experienced where someone pretended to be the landlord. I mean, that's a good one. I think it's mostly that they show up and they have access to files that they otherwise should not, right? They're bringing in a copy of the lease. They're bringing in the evidence to support the claim that they filed. They do sign a sworn statement with the petition that says, I am an authorized agent on behalf of this landlord entity. And when I get attorneys, then the attorneys will summon that person to come, because generally they need to be testifying of personal knowledge, especially when it's a lease violation and not just non-payment. Then we need evidence that this violation has occurred, and how would they know that?
Judge Spector, I mean, sorry, Professor Spector, sorry.
That's okay. I don't know if that's a promotion or a demotion. No offense to Joe. I think. What's that?
No comment, just laugh.
No comment, right. No, I was gonna say one thing about that, and then another thing about another issue that we were discussing. I think that requiring the paraprofessional to submit the paperwork is the way to go. That the tenant, right now, the tenant doesn't know that she can have assistance as it stands, or make a request for assistance. So I think that having the authorized representative, if they're a paraprofessional, provide that letter of engagement or a letter of representation, putting the burden on them and not on the party is the way to do that. The second thing I wanted to note, and it was as Ellen was talking about the state bar rules, your code of ethics. And I did note that there's likely to have to be a change there. And if you discuss this, and I'm going to apologize then for having missed it, but it's in section C of your code of ethics that prevents a paralegal from advertising or contracting directly with a member of the general public for the performance of legal functions. And so that, I gather, would be something that would have to be a rule change. It's a state bar rule, so it would need to be changed as well.
It's not, I mean, we would be separately approving the code of conduct or the court would. Somebody, I mean, it's not the state bar approved. The paralegal code might be state bar approved, I don't know. But what I'm anticipating is just using that as a guidance for the code of ethics that we want to apply to paraprofessionals. And I believe I have tagged that one that so we've gone through, I combed through one time, but again, my subcommittee has not talked about it, so I'm not wanting to talk about it here. But Grace and I have done a once over on that and made some changes to it. And I believe we caught that one for paraprofessionals. But thank you.
Well, because it might be that the paralegal is seeking certification as a licensed paraprofessional, and then they would be in a conflict position, it seems. Just something to think about as you discuss it.
That's a good comment. Thank you. When I have Okay, I have one more topic, and then we'll be done for the day after one of us gives an update on what's next steps. But one of the issues that we've talked about among the subcommittee that I am not ready to report that we have consensus on, and that might be helpful to get some input on from the working group, is the requirement that a paraprofessional maintain malpractice insurance and or disclose that they do not, whether they have malpractice insurance. So as I think everybody in this room probably knows, lawyers are not required to have malpractice insurance, nor are they required to disclose to their client whether they do have malpractice insurance. Other states who've adopted a paraprofessional program, most of them do either require malpractice or require notice, but all of them track what they do for lawyers. So to the extent a paraprofessional is required to have malpractice insurance, in that state, a lawyer is also required to have malpractice insurance. So if we were to propose to the Supreme Court that they're not require malpractice insurance, or that it shouldn't even be disclosed whether there is malpractice insurance, we would be consistent with other states in that we're treating insurance the same way as attorneys. With that said, I think we would love some guidance from the working group about what the consensus here about, we don't require it for lawyers, so we're not gonna require it for paraprofessionals, or is there more room to require, because they are paraprofessionals and they're not lawyers, should they have it? And also keeping in mind too, I think if we required paraprofessionals to carry insurance, that it would, a market would be created in Texas for it. But I also want to go back again, as I've worked on the regulatory angle of this project, I've just kept in mind so much that we cannot let the entry fee be too high, or we will be creating a program doomed for failure. So
I also think it would impact the rest of the paralegal practice in Texas. To create that market, then our malpractice insurance might go up in that question of, do you have paralegals that are doing these things? That it may be one of those things that's the unanticipated consequence of doing that, is that it increases the cost of legal service provision across the board.
any other comments on malpractice insurance?
My initial response is do what's done in other jurisdictions and don't require the licensed paraprofessionals to do more than the lawyers are required to do. Yes.
That's my initial response also, because we're also contemplating a system of paraprofessionals who are going to be employed by other people. Nonprofits, legal services, not necessarily, but in general. Likely, right? And so now we're just increasing the burden on nonprofits for cost. I don't know that makes too much sense. Particularly when lawyers are not required, or even to disclose.
And I think, as Richard was saying, we all are reporting our paralegals on our malpractice policies. We carry malpractice as nonprofits of legal aid organizations. But a domestic violence organization is not carrying a malpractice policy.
Right.
Or other social services where we might, from the community justice model, which is where I really think legal aid and the clients that we serve will really see the benefit is in that model. Those social service organizations, that would be an added burden for them, for sure.
But I think that the folks in Alaska said with their community justice workers is that they were with different organizations, but they were pro bono volunteers with the legal aid program.
Supervised by
And so, and they were supervised, and so they were covered under the malpractice insurance for legal aid.
Right.
And so we cover our pro bono. And so I think that would work, because then they would be covered. But to independently say, you're required to get it's not fair.
Yeah.
Yeah, I would like to have everyone have malpractice insurance. We can't allow lawyers not to have it, and require paraprofessionals.
Okay, well, it sounds like we have consensus to not require it, not disclose anything. Are there any dissenting voices who want to give feedback in 1 minute? Cutting you off because I disagree. Okay, well, thank you. That concludes my presentation. And do you want to talk about next steps? Do you want to? Okay. So we do have our next working group meeting set for November 2nd, I believe. We really, this will be the final working group meeting before our recommendation goes to the commission. So it is imperative that we have a strong attendance record at that meeting. We will do our best. We have not, I don't think any of us have set our upcoming subcommittee meetings. One survey has gone out, I don't think the date was set, right?
Yeah, we need to set them.
We need to set them still. We'll try to do better. I will try not to be having a subcommittee meeting on the day before the working group meeting so that the written materials to you is more complete than it was this time. But really put November 2nd on your calendar. I suspect it will be much like today as far as timing goes, sort of late morning start so people can travel to Austin and get here with a break for a working lunch basically, and hoping to end by 3 o'clock. So I would think, no, we haven't set this in stone, but I'm guessing November 2nd is going to be much like today. Is that what you think too? Okay, so get that on your calendars and the subcommittee members will be in touch. If any working group members want to give us feedback, either you're listening to this after we post it on YouTube and you have some comments, let me assure you that all 3 of the co-chairs welcome that input by email or by phone. So feel free, we would love to hear from you if you were missing today's meeting or if you were here today and just remembered something or had another thought as you get home. So anything else, Kenan?
Just 2 other things. One, there was an invitation that went out for the final meeting to the working group members, but we need to add our special guests, which we will fill the gap. I'll put a note to self now. And then 2, the National Center for State Courts, people who've been helping us, Lonnie Summers and Grace Spulak, invaluable, but in order for them to do the best job possible for us and the commission, this meeting on November 2nd has to have the votes, has to have decisions made so that they can put that report together in a timely manner to present to the commission, because the commission then needs to turn over the recommendations to the Supreme Court of Texas by December. So it's a quick turnaround time that we're working with, and I see that Lonnie, you are now visible. If there's something more you want to add there, please feel free to chime in.
Thank you, but I think you covered it.
Okay.
Our meeting is December 15th.
Oh, the commission's meeting is December 15th.
December what?
15th.
Okay, well, if there, if we don't, I guess that's
Is
it.
a motion to
There-
adjourn?
Can I get a motion to adjourn?
I move to adjourn.
Karen moves.
Karen moves. Can I get a second? All those in favor say aye.
Aye.
All right, thanks, guys. We'll see you soon.
Thank you.